It's 1 o'clock. We actually had a public hearing scheduled for the 5th, February 5th. As a fiscal court, we went into that public hearing and we recessed from that hearing. So we are now going to call the fiscal court back to order from that public hearing. So we'll go into the public hearing for the removal of a board member, Marvin Stokes.
Yeah, just very
Announce,
briefly, this is pursuant to 65.007. I'm just going to read the pertinent provisions here. Unless otherwise provided by state law, an appointed member of the governing body of a special district may be removed from office by the appointing authority after a hearing with notice as required by KRS Chapter 424 for inefficiency, neglect of duty, malfeasance, or conflict of interest. The hearing shall be initiated and chaired by the appointing authority. There isn't really a whole lot of law out there as far as or precedent on how these things are conducted that I'm aware of. So what we're going to do is I wanted to read that to remind everybody here that we're just here to hear facts on it. The alleged inefficiency, neglect of duty, malfeasance, or conflict of interest. So if anyone has anything that they want to say at the public hearing, we need to remember that that's why we're here, is to hear facts on those particular issues. So with that, the chair is the presiding officer over the hearing, and I'll turn it back over to Judge Neal.
Thank you. All right, we'll just get right into it. I want to make it clear, I'm the one that prepared the presentation for this public hearing to present it to the fiscal court. As the statute states, there has to be a public hearing, and so I'm the one that called this public hearing so that the facts can be heard. I'm just going to read what was submitted to Marvin, dated January 22nd, 2019. This was addressed to Marvin Stokes, Chairman, Marshall County Refuse Board, 3554 Lone Valley Road, Calvert City, Kentucky. Dear Mr. Stokes, I'm writing this letter per KRS 65007, removal of appointed member of special district governing body, hearing and appeal. The reasons for your removal are outlined below. Malfeasance. On January 5th, 2017, you came to my office with Rick Koch. As chairman of the Refuse Board, your discussion was regarding Marshall County Fiscal Court action taken on December 20th, 2016 regarding the Treasurer's Office salary schedule update to include fees agreed upon in the interagency agreements. This budget amendment by the fiscal court was approved. You stated to me directly, the way you voted in court did not sit well with others or with some folks, and it caused you to take some steps backwards. Your intentional conduct to coerce obedience as chairman of a special taxing district fell short. I strongly believe it was wrongful and potentially unlawful in your position as chairman. Your position has no voting authority on the fiscal court budget amendment, and more important, you created a conflict of interest in which you have demonstrated a duty to more than just the refuse board and unknown persons, but cannot do justice to the actual or potentially adverse interest of both. It was brought to my attention around May of 2018 the following: Rick Koch coerced Charlie Edwards into believing that I was going to remove him from the 109 Refuse Board, causing Mr. Edwards to resign in fear of being removed from the board. Koch then advised me that there was a vacancy on the board, and he suggested you for the appointment. Unaware of these events, you were appointed to the 109 Refuse Board. It is my opinion that you were aware of Koch's initiative. On January 14th, 2019, I gave you a courtesy call and advised you that I would be requesting your removal from the 109 board per KRS 65007. I advised you that I was presenting this to the fiscal court the next day, January 15th, 2019. The following morning, Rick Koch contacted Commissioner Justin Lamb, asking him questions regarding this matter. Commissioner Lamb advised him he knew nothing of it. It is a clear example of your conflict of interest with regard to official matters. This behavior continued throughout the course of your term as a board member and as a chairman of the 109 Refuse Board regarding fiscal court matters, which created an environment of inefficiency by failing to negotiate timely results and communicate effectively with the fiscal court regarding a host agreement with WastePath in an effective way. On February 27, 2018, Deborah DeLong and Lynn True, Recycling and Local Assistance Department for Environmental Protection, conducted a conference call with Marshall County Solid Waste Coordinator Jeremy Perrin and Tim Childs. This was confirmed by me communicating with Jeremy and Tim shortly after the fiscal court meeting on June 19, 2018. Deborah DeLong stated in an open fiscal court meeting that she spoke to me, you, Jeremy, and Tim during this conference call regarding a letter that you received from WastePath dated December 28, 2017. The letter proposed an expansion and requested a consistency determination from the 109 Board. You were present at this fiscal court meeting with the state representatives when she stated the conference call and who was on the call. I challenged Ms. DeLong when this call took place and who was on the call, and you mentioned nothing of the facts. However, a letter dated June 22, 2018, Gary Longston, Branch Manager, Recycling and Local Assistance, mailed you a letter as the chairman of the Marshall County Refuse Board stating this conference call. In this letter addressed to you, he states that you, along with Deborah DeLong, Lynn True, me, Jeremy, and Tim, were on the conference call. Once again, you did not take the liberty to correct, if needed, this inaccuracy of very important facts. On June 25, 2018, I spoke with Deborah DeLong and Lynn True with Marshall County Attorney Jeff Edwards about the statements of facts regarding this conference call and the official letter from Gary Longston. I requested that they retract parts of the letter dated June 22, 2018 from Gary Longston's address to you. The below information was sent to Deborah DeLong on June 27, 2018 by Marshall County Attorney Jeff Edwards. Please state who participated in a reference conference call February 27, 2018, specifically whether or not Marshall County Judge Executive Kevin Neal participated. Please state the date of the Marshall County Fiscal Court meeting attended by yourself and Lynn True. Please restate your reference to a committee and reference to the individuals who have been participating and working on the new host agreement. No formal committee has been established by the fiscal court. Deborah DeLong responded on July 3, 2018, officially retracting the above information. There were no responses or comments from you as the chairman. You were included in the entire correspondence with Deborah as the chairman and never mentioned you did not take part in a conference call or that the 109 Board formed an official committee. September 6, 2018, the fiscal court officially created a host agreement committee consisting of Koch and me. It was advised to me by another 109 Board member on July 13, 2018, that the 109 Board formed a committee to discuss actions referenced in the letter dated December 28, 2017, regarding proposed expansion and requested consistency determination. That committee was you, Jeremy, Tim, and Denny Knoll. The official fiscal court approved minutes of March 23, 2018 states action taken by the court only to amend Ordinance 9201, 2% per annum of gross receipts. License fee applicable of off-site waste management facilities located within Marshall County, Kentucky. And all voted aye, motion carried. There are times when the 109 Board committee would meet and not have their counsel, Denny Knoll, present. Negotiating meetings with WastePath without their committee counsel present April 23, 2018 and May 15, 2018. Attending the fiscal court June 19, 2018. Unknown all parties present July 3, 2018 in Calvert regarding host agreement discussion. A direct lack of communication to my office and county attorney regarding notice to the July 3, 2018 meeting. During the May 15, 2018 meeting, it was made clear You do not know the county attorney drafted a host agreement and circulated that draft for review. You failed to utilize your resources directly by the 109 board, failing to use your board attorney because he costs money, time, and material in an effective way is a direct reflection of inefficiency of handling the negotiations of the host agreement for the 109 board committee and possible litigation the 109 board and county could be facing. This information comes from another board member who is concerned about your handlings of the 109 board. I've been contacted several times during the past year regarding concerns of the 109 board, specifically the actions of you and Rick Koch by another board member, Danny Newton. He explained in one event that the board motioned to go into executive session to discuss business, and Koch would not leave the room so the board could discuss business. December 27th, 2018, I met with Danny Newton, and he requested that my office take over the negotiations because of concerns he has with you and your lack of handling the affairs of the 109 board negotiations and no confidence in you. I have set a public hearing per KRS 65007 for February 5th, 2019 at 1 p.m. Location will be the Marsh County Fiscal Courtroom, 1101 Main Street, Benton, Kentucky, 42025. The hearing shall be initiated and chaired by the appointing authority, who shall prepare a written statement setting forth the reasons for removal. The member to be removed shall be notified of his proposed removal and the reasons therefore by registered mail sent to his last known address at least 10 days prior to the hearing. The person to be removed may employ counsel to represent him. A record of the hearing shall be made by the appointing authority, and that's from Marsh County Judge Executive Kevin Neal. We do have a recording of the proceeding, and I can tell you there's familiar faces in the crowd. This is not comfortable at all. It's unfortunate, in my opinion, but it's part of the process. The statute outlines what we have to do, what I have to do to remove an individual from a district. And that's the process. We're going to follow the statute. But growing up with you, Mr. Stokes, and even, growing up with your kids, it's not fun. It's not easy. But from the looks of people in the crowd, they're upset. I'm upset. But here we are. And I stand with my convictions. I strongly feel what I wrote, and I'll stand behind it. This is a process, and we're going to have to go through that process. And I'll go ahead and make that apology now that we have to go through that process, but I'm standing behind my convictions. So I understand that, sir. Do you have counsel? Okay. Can you state your name, sir?
Do I need to go here?
Yes, please. I think Denise has got that turned on.
My name is Chris Hendricks. I'm an attorney in Murray, Kentucky, representing Marvin Stokes.
Did you say Hendricks?
Hendricks. Is it okay if I move this? I don't like it in my face
Go ahead.
as much as I can. There we go. May I proceed, or do you have
Yes, sir.
additional information you'd like to provide?
No, go ahead.
All right. Judge, I would like to ask you some questions regarding your statement or your letter, if I may, please.
Go ahead.
First, I have some questions, procedural questions. The decision to seek removal of Mr. Stokes from the Refuse Board, that was made during a fiscal court meeting of January 15th, 2019. Is that correct?
I believe the fiscal court was advised of what my intentions were.
Okay. And during that meeting, or during that fiscal court meeting, the discussion regarding your intention to seek removal from the board, the notice required by statute, the publishing of the notice, that would have all been discussed during the executive session that occurred on January 15th, 2019, correct?
In executive session, they were given the statute.
Okay. I don't know what that
statute-
means in response to my question, sir.
Well, let me read the KRS 6507007, and 425 for the advertisement, KRS 425.
So the members of the court were provided a copy of that statute during that executive session. That's what you're telling me?
They were advised of those statutes.
Thank you. I'm definitely not an expert on procedure of the fiscal court, but what action was then taken by the fiscal court in regular session regarding the discussions that happened in executive session about the public notice, the publishing, notice to Mr. Stokes, and your intention to remove him from the 109 Refuse Board?
There were no actions taken.
Okay. So is there no requirement to seek approval from the fiscal court to, I guess, spend the money to publish that notice, to send the certified mail to Mr. Stokes, to do all those procedural matters that are required in general session?
If there's a statute that says that that has to be done, I'm not aware of it. But I have funds in my account for advertisement that are budgeted dollars, if that's what is
Very
in
well.
question.
The point I'm trying to make is that you would agree with me that no, just so I can get this on the record, no official action can occur by the fiscal court in executive session. That's correct, sir.
Our minutes that have been approved do not reflect any action.
And so then no, you're saying your minutes in the regular session on January 15th, 2019 don't reflect any action regarding this reason we're here today, right now, from that date?
Nothing in the minutes.
Wouldn't you agree with me that a majority of the allegations against Marvin Stokes occurred 1 to 2 years ago, according to your letter?
For my letter, it's got the dates on there, yes.
And actually, I've reviewed your letter many times. The most recent factual allegation outlined in the removal letter was no more recently than 7 months ago, and that's in the case of the conference call. Isn't that correct?
I'd have to look at it, but if that's, if you reviewed it,
The most recent date stated in your letter is July 3rd, 2018, which actually isn't a reference to
July
Mr. Stokes
3rd
at all.
was a meeting that I couldn't tell you who attended. But it is referenced in my letter, yes.
Okay, and it states that Deborah DeLong responded on July 3rd, 2018, officially retracting the above information that you outlined above. That's the most recent date stated regarding any of the allegations against Mr. Stokes, isn't that right?
Well, December 27th, 2018, I met with Danny Newton, and he requested that my office take over the negotiations because of
Right.
concerns with your client. So
There are no
December
factual
20.
allegations listed in that paragraph, though, are there?
I think Danny sitting in front of me is factual.
I'm asking you a direct question. There's no factual allegations listed in your letter regarding that paragraph of December 7th, 2018. Isn't that correct?
In that paragraph, Danny Newton requested that my office take over negotiations. I think that's factual. He specifically asked me to take over negotiations. Now, does the board have to approve that? Yes, but that is factual.
According to your letter, you would actually, I think you kind of just answered this question, but you would agree that this attempted removal and the hearing that we're here for today was actually instigated by Danny Newton. Is that correct?
No?
That's not what your letter says?
No. I'll read this to you again for the record. December 27th, 2018, I met with Danny Newton, and he requested that my office take over the negotiations because of concerns he has with Marvin and the lack of handling the affairs, the 109 board negotiations, and no confidence in him.
That same paragraph that says, "I have been contacted several times." Would you read that first sentence for me, please?
Yeah. And I've got a schedule of when I've been contacted by Danny Newton on various things that go all the way back to March of 2016. So I don't see where that sentence is saying that Danny Newton is the one that's,
Well, since you won't read it, I'll read it. It says, "I have been contacted several times during the past year regarding concerns of the 109 board, specifically the actions of you and Rick Cock by another board member, Danny Newton." So based on those two sentences, you're telling this court that this was not instigated by your discussions with Danny Newton?
no, no.
Okay, thank you. Wouldn't you agree that any citizen of Marshall County is welcome to attend a fiscal court meeting?
Yes, it's a public hearing.
And wouldn't you agree that any citizen of Marshall County is welcome to meet with you or perhaps your deputy to discuss concerns he or she may have with actions taken by the court?
It happens all the time.
Okay. And Marvin Stokes is a citizen of Marshall County, isn't that correct?
He's a citizen of Marshall County, that's correct.
So, in reference to your allegation regarding the meeting of January 5th, 2017, how exactly is Marvin Stokes discussing concerns with you any different than any other citizen of Marshall County?
And that's a great question. If you go back, have you looked at the minutes when I actually went to the 109 board and discussed this actual contract that's in question?
No, sir.
The 109 minutes?
Please
Okay.
enlighten me.
I went to that meeting. Communication through the audit office, the way we had been doing business with not only just the 109 refuse board, but also with the clerk's office and with the tourism department, we were paying our employees directly. When it was brought to my attention, I reached out to the state auditor's office. They said two things can happen. Either we can pay them overtime, or the monies go through the fiscal court. All monies go through the fiscal court. That made sense to me. So that's what we started. Dennis Faust drafted these agreements. He delivered those to Tim and the tourism committee. I went to the refuse board, and I sat down personally with the board and explained the agreement that we were going to have. If we're going to have a relationship, monies are going to come through the fiscal court, we're going to have to document that relationship. And that information was from the state auditor's office. In that board meeting, your client argued that he didn't want the monies to go through the fiscal court. He wanted the monies to go directly to the employees. I could not guarantee that. I am one voting member of the fiscal court. But what I did guarantee is that if we are going to have a relationship where our treasurer's office is going to be doing the books for the refuse, we're going to document that relationship, and the monies will go through to the fiscal court. Once those monies go through the fiscal court, as the state auditor's office had explained, it now becomes the fiscal court's position to compensate their employees or not. As far as I was concerned in that meeting, I explained that to him. Even other board members explained that to him, that I can't just draft a document where those monies bypass the fiscal court and go straight to the employee. So to answer your question, your client being in my office with Rick Koch, he was not there as a citizen.
Okay.
And the discussion was not pertaining to the agreement that the 109 board, as a chairman, I could see discussing that. It was the compensation of county employees, which he has no authority to discuss because the fiscal court had already taken action.
He has no authority to discuss. I mean,
In the manner that he discussed,
anyone
no.
could discuss that with you, though. Isn't that correct? That's county business, isn't it?
Let me put it on record. As the chairman of the 109 board, he has no authority to take action on that, on how that was voted.
I don't see how talking to you in an informal meeting is taking any kind of action. How is that action?
Well, you say informal. It wasn't an informal meeting. It was an intentional meeting that him and Commissioner Koch had.
You called the meeting, though, didn't you?
No, I did not. Let me be clear. This is twice now that I get told I'm in these meetings. I didn't call the meeting. They showed up to see me.
Okay. I'm still confused about how him coming to see you and discuss county business is trying to take some kind of action.
I would say it was the content of the conversation.
One of those, I guess you had to be there kind of things.
Yes.
Okay. And that was 2 years ago, and none of us were there, except for you two.
The three of us were there.
Okay. All right.
I have one question. Just for my clarification and to clarify the record, I believe you said Marvin, referring to Mr. Stokes, didn't want the money going through the fiscal court, wanted it to go straight to the employees.
That's correct.
The employees are who you referring to?
Wendy, or Emily, Brenda, and Karen.
Treasurer's
the
office.
treasurer's office.
Does, so Marvin's the chairman of the refuse board. Even in his official capacity, he has no authority over the treasurer's office, does he?
Not when it comes to compensating them with monies from the county general fund, no.
Okay, thank you. Regarding I guess the middle paragraph on the first page of your letter, resignation of Charlie Edwards. Charlie Edwards resigned from the refuse board in 2016 for health reasons. Isn't that right?
I don't know.
Well, he actually wrote a letter of resignation to the fiscal court citing his poor health as the reason he was leaving the refuse board. Do you recall that?
Nope. I mean, he did write a letter, but I haven't seen the letter. I'd have to read it again.
Well, I mean, it's a matter of public records. I've watched it, so.
You're asking me if I can recall that letter. I haven't.
Okay, all right.
No.
And then during that meeting, before Marvin Stokes was suggested, there was actually someone else suggested to take that spot on the board. Do you recall that?
By who? Because
I believe you were leading the discussions. I know it's been 3 years, but
leading the discussions in fiscal
as
court.
Yes, the fiscal court, as far as who to appoint to replace Charlie Edwards.
I'd have to pull the minutes.
Do you recall being the one that made the motion to appoint Marvin Stokes to the refuse board? I can cite you to the date and time. You want to get a bottle of water somewhere? Here's one. Are we going to try and pull up that video, or?
She's pulling up the minutes. The minutes are the official record of the court.
Do you need the exact date?
She's got it.
I got it.
Denise, can you hear me? I'm just going to read this. This is the official fiscal court minutes. April 19th, 2016. Is that your date?
Yes, sir.
Judge Neal read a letter of resignation from Refuse Board member Charlie Edwards effective immediately. There was no discussion on a replacement for Mr. Edwards. A motion was made by Judge Neal and seconded by Commissioner Koch and to appoint Marvin Stokes to the Refuse Board. All voted aye. Motion carried. That's the official record.
Thank you. So you seem to suggest there was some kind of coercion for Charlie Edwards to resign his position on the refuse board. That's complete speculation, isn't it?
No, that was actually a conversation with Charlie Edwards.
What, could you explain in more detail that conversation with?
Sure. It was advised to me that that took place probably about a year ago, last year, sometime spring of last year. I had no knowledge of that happening, so when I ran into Charlie Edwards, I'd never met Charlie Edwards. When I got elected, I couldn't tell you who Charlie Edwards was. But I asked Charlie to come to my office and talk to me. I wanted to personally look him in his eyes and ask him, did this actually take place? Because if it did, I don't condone that type of business. That's not how I'm going to operate, and that's not how I'm going to run my affairs. And he stated that, yes, that did take place. That he was basically told that I was going to remove him from the refuse board.
Why did you ask Charlie Edwards to come talk to you about that?
Because I was told that's what happened. So I wanted him to confirm that that's what happened. And he confirmed, yes, that did take place.
Is it your understanding from talking to Mr. Edwards during that conversation that that's the reason why he?
Resigned, yes.
In the last sentence of that paragraph, you write, "It is my opinion that you are aware of Koch's initiative."
Well, yes, Koch was the one that told him I was going to remove him from the board.
You can't.
I have an
You
opinion.
can't sit here and tell everybody you know that Marvin Stokes, if that's true, knew anything about that.
Over the course of 3 years, I hate to say it, but that's my opinion, yes.
Your opinion is not personal knowledge, though, is it?
Based off of the personal knowledge of the events that have taken place and the character that I have seen demonstrated from others involved in that conversation, in that situation, yes. That's my opinion.
Okay, I want to talk about this conference call. It was ultimately determined that Marvin was not involved in this conference call, is that correct?
Say that again?
It was ultimately determined that Marvin Stokes was not involved in this conference call, is that correct?
I haven't seen anything that states that he was or was not involved.
Okay. I have to admit, the first time I read this letter, and then every time since, I have a very hard time understanding why it is material to anything involved in the operation of the refuse board, whether he was on this conference call or wasn't.
Let me ask you a simple question. If someone were to say that you were involved in a conference call and you weren't? Do you think that, regardless of the subject matter, do you think that you would acknowledge that you were not or that you were involved?
Well, sir, I'm not the one whose job's at stake. It's not my job here to provide facts. It's my job to ask questions. So I'm asking you, how is that material to anything involved in his service as chairman of the refuse board, whether he was on this conference call or not?
With the nature of the information that was discussed, and even being stated in a public fiscal court meeting, if I am basically accused of being on a conference call with people talking about official matters, along with a chairman of a board, I'm going to ask what conference call, as I did, and who was on this conference call. I don't know anything about this conference call. Me, as a presiding figure over this fiscal court, I asked those questions. I even went further, and I asked them to redact that information because I wasn't on that conference call. That's what I found out. Now, in their literature, he was stated on that conference call. I can't tell you if he was on it or not. But talking with Tim and Jeremy, they said it was Tim and Jeremy. But that's all I've got. I don't know who was on that conference call. But I know this guy wasn't on that conference call. And I've got the official documents retracted that I was not on the conference call.
Have you since learned what the subject of that conference call was?
If, to my knowledge, it was letter of, it was the determination letter discussing that, if I had to go back without looking at any other documents.
Okay. So it's your, I mean, you're telling everyone that you consider this an extremely important fact, whether he was on the call or not. I think I'd like to know what the subject of the call was, since it's.
Well, just like what we're doing right here in a public hearing. We're in a public setting in a fiscal court meeting, and there are individuals identified on a conference call. He's sitting right there by the people, he came with the people who said he was on a conference call. They said I was on a conference call. It's in a public hearing or a public meeting discussing information regarding to facts that we're going to be taking actions on or anything. But if you're not involved in a conference call, I'm going to speak up. I wasn't involved in that conference call. I think that is very important to clarify the facts. Do you not agree? Well, I can tell you. I can tell you, when we're dealing with, just like when we're reading the official minutes of fiscal court, we document things. That's why I wanted to make sure that they documented correctly. So yes, I think it's huge. It's just something simple in my mind. If you're not involved in a conference call, you state the facts.
But again, that's your opinion, correct?
Factually, that's my opinion, yes.
The subject matter, to your understanding of that conference call was what again?
I wasn't on it.
Well, you said it was termination of.
I don't know. If I had to go back and review, I would say it was a letter of termination. I don't know. I know talking with Jeremy and Tim, they were the ones speaking with the state officials. I don't know what the conference. I can tell you I wasn't on it.
There's discussion in your letter regarding use of the 109 refuse board's 109 refuse board's attorney, Denny Null.
It states what they were talking about. Does that need to be stated on the record?
Yeah, go ahead.
Okay. Let me back up for a second. This is referring to the conference call and what the material was. This is from the Energy Environment Cabinet, June 22nd, 2018, and this is addressed and sent to Marvin Stokes as chairman of the Refuse Board. In a conference call held February 27, 2018, Deborah DeLong and Lynn True of my staff spoke with Marsh County Judge Executive Kevin Neal, Marsh County Solid Waste Coordinator Jeremy Perrin, and yourself, representing the Marsh County Refuse Disposal District regarding a letter that you received from Waste Path Sanitary Landfill dated December 28, 2017. So that's the letter proposed an expansion and requested a consistency determination from the Marsh County Refuse Board. During the call, our staff explained the process of completing local determination and discussed the benefits of host community agreements. So that was the content of that call.
On the third page of your letter, you discuss about, or you make allegations regarding Marvin not utilizing the services of the 109 Refuse Board's attorney, Denny Null. Do you recall it being discussed during a fiscal court meeting that Denny Null and the county attorney at that time, Jeff Edwards, would not actually be members of the formal committee negotiating the host agreement?
Yeah, they're never members, but they do participate.
Instead, they were to act as legal advisors once the agreement was brought forward before their respective bodies for discussion and decision. Is that fair to say?
If the fiscal court forms a committee, and I am to be a member of that committee, I will have counsel with me during the discussions.
Okay, that's for the fiscal court, right?
I'm just telling you, if I'm in a committee, I'm going to have counsel with me anytime I sit down in negotiations, discussion, because if a legal question gets asked, I defer to counsel.
Are you on a committee with the 109 Refuse Board?
September 6th, there was one appointed by the fiscal court.
That's great. Are you on that committee?
The fiscal court put me and Commissioner Koch on a committee September 6th of 2018.
Okay. Have you attended meetings?
One meeting.
Okay. And the county attorney was present during that meeting?
He was.
Thank you.
And so was Denny Knoll. But in regards to my letter, these meetings I outlined specifically, they were before September 6th, so there was no committee by the fiscal court.
Were you present on April 23rd, 2018? At this meeting?
Is that on my letter? Are you looking at my letter?
It says, negotiating meetings with Waste Path without your committee counsel present, April 23rd, 2018, and May 15th, 2018. Were you present at both of those meetings?
April 23rd, yes, I was there.
And that was a meeting of the 109 Refuse Board?
I believe that was the first meeting I'm being told that there was a committee formed by the 109 board, and myself, counsel, and Rick Koch was there, Commissioner Koch was there.
What about May 15th, 2018?
May 15th, 2018, I believe, was the second meeting. Same, I believe Tim and Jeremy were also at the April 23rd and 15 meeting.
Okay. Were you present on May 15th?
Yes, I believe so, if that's what I've got there.
The host agreement that was distributed on May 15th, which you refer to in your letter, right below that section we were just discussing, that was copied from a Graves County host agreement, is that correct?
Actually, it was distributed to all the members that were present prior to May 15th.
Okay.
That's what I'm referring to. There was a copy of that was sent out to everybody.
So
It was
the-
actually requested that the county put a draft and agreement.
So the host agreement that was discussed on May 15th, 2018, was that copied from, or at least there was a Graves County host agreement that was utilized to draft that agreement. Is that correct?
Jeff Edwards drafted that. There were several host agreements. Graves County was probably one of them, but there were several host agreements.
Several,
You would have to ask him directly how he
Okay.
drafted that.
well, several drafts, or there were several examples that he used?
There were several examples that were in his possession, yes.
And was Marvin Stokes the chairman of the refuse board at that time?
I believe, yes.
Okay. Yet it appears he was purposefully left out of the chain of distribution for that draft. Is that correct?
No, that's not correct.
Well, then,
I don't think anybody,
why would
Purposely-
why would he not have had a copy prior to the meeting?
I don't know. But Jeff is the one who distributed that host agreement.
Are you familiar with Brian Miles?
I am.
And Brian Miles has been involved extensively in the host agreement process with this county, is that correct?
He's been to several of our meetings, yes.
Give me time out just for a second. You mentioned a chain of distribution. What are you referring to, like an email?
An email.
Or an email?
I have no idea.
It's an email.
However it was distributed.
Well, you,
Yes.
you insinuated that he had been left out of the distribution. I didn't know if you had anything
I don't
specific
know
you
if
were
it was
talking
mailed,
about.
hand-delivered, emailed.
It was emailed.
Okay, I don't know.
If the correspondence from Jeff was all done by email. I mean, we even in open court put the correspondence on the TV to show everybody that the communication, the information was out there. So it's if you want to get specifics, you're going to have to ask Jeff, but
Okay.
he drafted it and distributed it to everybody.
And are you aware that Brian Miles never received a copy of that host agreement either?
He stated that in one of our meetings.
And back to the question right before that, he's been heavily involved in that negotiation and drafting that host agreement, hasn't he?
Well, he stated, I can tell you that he stated that he didn't receive it. But again, Jeff, having a list of people that he was disseminating that information out to, that's all the information I have. I can tell you that through the communication that day, May 15th, Brian Miles negotiated that we did not have a host agreement, and in my opinion, that we had the cart in front of the horse.
Was a copy of that host agreement distributed to the waste path?
I don't know. In that correspondence? Oh, yeah. Here's the email from Jeff Edwards on June 28th. This is the correspondence. It goes to Brian Miles, myself, Marvin Stokes, mssolidwaste@gmail. I don't know who that is. mssolidwaste@gmail. So that's just an example of correspondence that is sent out. I'm sure I know Rick's email was in some of them, so, but you're going to have to ask Jeff to provide that.
Okay. The last topic I want to discuss is this executive session allegation with the 109 board. Do you know when specifically Rick Koch attended the refuse board when he allegedly refused to leave for an executive session?
No, if you notice in my letter, that is coming from Danny Newton, that occurred. I'm basically stating in my letter that that occurred from Danny Newton,
Okay. And
telling
you
me that.
You weren't present when this
I was not
allegedly
present,
occurred.
no.
Thank you. That's all the questions I have.
Do any of the fiscal court members have any questions about what's been discussed thus far? You have anything you want to add?
I requested the minutes. I haven't found in the minutes as far as a committee that was formed for the 109. I went all the way back. I know that was addressed in open court as far as a committee being formed, but I went back and looked at the minutes. I would think to form a committee, there would be an action item, and I may have looked over it, but I think it's very important. The whole basis of this was that when we were notified, March 23rd of 2017, or 2018, that we needed to have a host agreement. We were advised that later that the 109 board had formed the committee, and I don't know if there was ever a committee formed, but I went back and pulled the minutes, and I haven't seen anything. And again, I may have overlooked it. I don't know. Do you know when the board was forming a committee?
Do I know when it was?
Yeah, when the 109 board formed the committee?
Oh, we formed one, but it was, when it left the refuge, Indianola was part of it, and that was changed later. But I couldn't tell you the date on it, no.
Okay.
But it was formed.
I think the minutes that I got went back as far as August of 17. So I don't know. I didn't see anything forming a committee. And if you go back and you start from the beginning when all this came about, the county hasn't had a host agreement since '94. And when it was advised to the fiscal court, myself and the county attorney, that we needed a host agreement, this is something simple. We sit down, we negotiate a host agreement. But apparently
May I ask you a question? You just stated that that was something simple?
to sit down and negotiate a host agreement.
That's simple.
To sit down with people, yes.
Okay, but
The
all right.
content of a host
I wanna make
agreement
sure I'm clear that you
could
think
be.
that's simple.
Yes. To sit down with folks and come up with a host agreement should be simple. When that was brought to my attention that we needed a host agreement. And here we are, almost a year, well over a year later, and we don't have a host agreement. We don't have the changes to the ordinance. There were a lot of things that took place outside of my office that myself and the county attorney at times would not have that information. And it's hard to sit down and work together as a 109 district and a fiscal court when we don't have information.
Let me ask a question now that, sorry, you guys are going back and forth. I have to look back at my notes to, about what you're saying. But so, first question I would have would be to the judge. You mentioned a conflict of interest. He asked about that. You talked about it. I mean, in a conflict of interest, there has to be two parties involved. Obviously, you mentioned, I mean, his position on the refuse board. What would be? I don't think you say specifically what the other interest is that you feel like.
Yeah, no, and that's a great question. When you look at, I put it in here. If you look at the first paragraph, Marvin states, the way you voted in court did not sit well with some folks, and it caused you to take some steps backwards. I don't know what that means. I don't know what folks they were talking about, and I don't know taking steps backwards. I can tell you what I perceived it to be, is that the way I voted, which I voted to compensate the employees, and Rick voted against it. They came to my office 2 weeks later to discuss specifically that vote. So as the chairman of the refuse board, you can't serve the 109 board and then an unknown group of people. I don't know who those people are. But to come in and tell me that the way I voted set me backwards with some folks, I don't know how anybody else would take that, but I don't know
Is it,
how you can serve two.
is it okay for me to ask
Yes, sir.
that same question? I mean, I feel like obviously you both deserve to answer
Sure.
that. Do you, first question, Mr. Stokes, I guess, is do you remember making that comment? If you do, then do you remember?
I don't remember making that comment exactly that way.
Okay.
This meeting was an informal meeting. Judge Neal had talked to Commissioner Cox after the December the 20th meeting, and he just wanted an informal meeting, like an olive branch meeting. As far as him was talking and things like that, we had settled that in November. At the Christmas party of the Refuge Christmas party, December the 6th of 17, I signed his interdepartmental agreement. As far as I'm concerned, democracy was over. We went to that meeting, and because Doc invited me, because I knew all of his siblings, his mother, my mother, were great friends. I knew all of his uncles. One of them was the best friend I ever had in my life. But we talked everything from UK basketball to Kentucky basketball, and if that was brought up, it might have been brought up in some matter, but there was many matters that was brought up. It was about a 2-hour informal meeting. But as far as me going back, and the main thing about it, I think he said that we disagreed about wanting to give the money to the Treasury Department, things like that. Our question was it even legal to give it to them that way? That was my original thing. It happened before I ever got on the board. It happened in 15. But as far as that being a direct statement like that, I can't remember that. And later on, I'll probably be up there and answer more questions about that. But it was many topics discussed there. This was an olive branch especially between him and Commissioner Cox, because he wanted no hard feelings over how the votes went down. And Doc was like me. Democracy took place. Ours took place in November. I signed the interdepartment agreement at the Christmas party on December the 6th. So, any other questions?
Well, that was,
I've got one. You referenced, Marvin, a 2-hour meeting. That meeting that you and Rick came to my office was not 2 hours.
How long do you think it was, Judge?
It wasn't 2 hours.
I can't say accurately 2 hours, no, but it was a lengthy, informal meeting.
It was not a lengthy, informal meeting.
Okay?
We
I
can sit
mean,
here
I-
and agree to disagree on
I'm-
that.
right.
I don't think anybody was keeping a stopwatch that day.
Was it an informal meeting, and was there not a lot of topics discussed?
No, it was very specific.
Just that one topic?
Yes, you actually even got up and said to Rick, "We're not getting anywhere here. Let's go."
That is inaccurate, and I'm going to prove later on that there was a lot more things discussed in that meeting instead of that
You
one
you might be getting the meetings mixed up.
No, I'm not getting the meeting mixed up.
Yeah.
I can tell you.
Because we only
We'll-
met once on this issue, and it wasn't a 2-hour meeting.
And there was more than that one topic in the meeting we're talking about. And it's the last meeting I was in your office about that. But I'll have more answers for that anymore. Mr. Collins, anything else?
Another question I had, just not necessarily for you or your counsel, was do you actually have the letter from Mr. Edwards from when he resigned, or do we?
We
That's
got it.
for y'all. You've got it.
I just
Okay.
read it.
Oh, you did. You read
I
it.
think you read the minutes.
He read
I think
the
you
letter.
read the minutes. I wondered. You mentioned you referenced the
I
letter.
Here's-
referenced it because I watched the video.
I'll just read it. This is April 12, 2016, resignation. Judge Neal, I appreciate the fiscal court giving me the opportunity to serve on the refuse board, but with much regret, my health will not allow me to continue to serve on our community effectively. I'm writing to notify you that I'm resigning as a board member of the Marshall County Refuse Board. My resignation will be effective immediately. I appreciate that time I was allowed to be on the board. If I can assist with the transition, please let me know. Sincerely, Charlie Edwards.
Monty, if you would like to review exactly what just happened and It took place on April the 19th, 2016, in the Marshall County Fiscal Court meeting. This young lady was here taking that meeting. We can put that right up on the screen, starting at the 13:57 mark for 4 minutes and 3 seconds. And I think that's a very important part of this discussion. And the letter was read from Charlie Edwards, and in his own words. Can we play that? We have technology to play that. It takes 4 minutes and 3 seconds, and I think a picture paints a million words, and that's very pertinent to 3 commissioners that have no idea what we're talking about through this thing. Would you all like to see that for your decision?
I mean, as far, I can't speak for them. As far as I'm concerned, the answer, I mean, he read the letter. I think that's the essential, you know, my question was, what did that letter say? And he just read it. So I appreciate that, but I don't think it's, you all may disagree with me, and you're more than welcome to.
When did you start on the board, Mr. Stokes? Do you know?
When did I start on the board?
Yes, sir.
May of 16. I fulfilled 2 months of Charlie Edwards' term, and then I was reappointed July 1 of 16 for a full term.
4 year, is that
Yes.
4 years? Sorry.
Yes, 4-year term.
Y'all have any other questions?
Have you been chairman the whole time?
Have I been chairman the whole time?
Yes.
I was appointed, Danny Newton resigned first meeting of July of 16, and I was appointed to take his place. Been chairman since July 16.
I guess this is just not necessarily something that we've gone through, and if this is not a proper question, someone tell me. I'm not a judge, by the way. This is not a position I've been in before, obviously, but do you feel like you've done this position that you've not let any personal animosity, because we know, I mean, it's fairly obvious, I think, here, you know, that none of that has gotten in the way, or what do you feel?
Well, I feel we had some conflict on the board out there at times, but later on in the discussion, I'm going to tell you what I've tried to do to improve the recycle and stuff like that out there. I'm going to answer those questions and show you how effective I was.
Okay.
I do have
You-
information I would like to go over with Mr. Stokes. If you
Okay.
want me to do that first. Anybody, any other questions?
We got one more. You mentioned board conflicts. Can you elaborate on?
You know how
any of
boards
those?
is, sometimes it's a 3-1 vote, but you lose, that's democracy. So you get up and go on and try to do the best you can. Win some, lose some.
Chris, are you ready to go ahead and?
Yes.
Okay. Just as a matter of me wanting to know, aside from Mr. Stokes, do you have anybody else that you're gonna?
Yes.
Okay. How many?
I have at least two more lengthy persons that I would like to speak, and then one short one.
Okay.
Should I proceed with Mr. Stokes?
Yeah, go ahead.
So regarding just briefly, regarding the meeting on January the 5th, 2017, you wanted to provide some additional information about that?
Yes, I do. To contradict what the judge said there, is that we talked about several topics, including basketball and things like that. The last thing we talked to him about, and he said, which this was an olive branch meeting. This was no harsh meeting, anything like that. He says, is there anything else you think I could do to help this county? I said, Judge, I've been informed that your overtime policy for the road department, which again had nothing to do with the refuge, for the road department and the park departments, is not fair to the employees. And the judge said, I think, Marvin, you're misinformed. That has been changed. I said, if that be the truth, I apologize, Judge. I said, but I just know what I've been told. And I said, I don't think it's fair to the employees. He said, I will check into that. That afternoon, 2-3 hours later, he called me at the house. And he said, Marvin, you was right. It has not been changed, but it will be changed. So that showed you that meeting went on for a pretty good determined time, and it was more than just that one subject talked about.
I'm going to respond to that. I know now you're getting your meetings mixed up. That was not the same meeting.
It's the only one me and you and Doc Hawk ever had.
It's not true. That's not
That
the same
is true.
meeting. Mm-mm.
That is true, Judge.
Would there be any minutes for these meetings that were kept, Judge, between Mr. Stokes and Mr. Cox?
No, as we stated earlier, people come in and talk to me. There's no legal standing that we have to take minutes.
Marvin, I want to ask you some more questions about your service as, if I may proceed. I'd like to ask you some more questions about your service as chairman of the Refuse Board. There's been a great deal of allegations made against you regarding your inefficiency as chairman. Let's talk about some of the things that you've actually accomplished as chairman. When you became chairman of the Refuse Board, how many cardboard recycling customers were in Marshall County?
Approximately 42.
And during your service as chairman, how many total cardboard customers were you able to develop in Marshall County?
Well, I knew from being out there and being chairman, we had to get the revenue up. Easiest way to get the revenue up was through cardboard. And I knew there was more than 42 businesses in this county that needed cardboard. We could sell it by saying, we'll put you a bin out here. You can probably get rid of one of your dumpster boxes. We pick up your cardboard 3 times a week. We take it, make something off of it. You can get rid of your dumpster. It keeps it out of the landfill, and we can save trees, and we can make a little money on it.
Okay, so how many currently customers recycling cardboard do you have?
Right now, I cannot give you an adequate number because some is dropped off and some we picked up. But I stopped at 130 there because I wanted to make sure that the employees and the inmates could take care of what I was bringing in.
Okay, and did you recruit major manufacturers to participate in your recycling program?
I did, and then it caught on, and then they contacted me and wanted it on board.
Okay, and can you give just a summary of who some of these manufacturers are?
Okay, don't hold me to it, because put this off the top of my head. We got Arkema, we got 3 bins there. We got Ashland, we got 3 bins there. We got Degussa, we got Estron, we got Sackasui, and we got Westlake. And then by not being able to take inmates in there, the refuge part runs those plants on Tuesday and Thursday.
Okay. When you became chairman, what was the annual revenue of recycling in Marshall County?
Well, I want to say it was less than $20,000, but I look back in the budgets and they dropped the budget for bringing in from revenue for recycle went from 50 to 40 to $25,000.
Is that what it was when you became chairman?
Somewhere in that area, yes.
All right. And what is the current approximate annual revenue
Well,
attributed to recycling?
in the fiscal year ending December 17, 18, recycling brought in $96,000 revenue.
During your tenure as chairman, did you have an employee retire?
Yes, I did.
And was he replaced?
No, he was not. We moved, he was a mechanic. We moved one of the employees over from recycle to mechanic and didn't have to hire anybody.
And how much money did that save the county?
Well, probably at that time, right now, it's around $70,000, probably $65,000 to $70,000. And that was in the same year that I got the cardboard push on.
When you became chairman, were there any bylaws for the 109 Refuse Board?
No, no bylaws.
And what did you do about that?
Well, everything I read and everything with Robert Rules of Order, any boards, they suggest any board have bylaws.
Did you get bylaws prepared?
Yes, I convinced the board to get bylaws, and we contacted attorney Denny Null, and Denny Null wrote them up, and we went over them, and agreed on them, and voted on them, and we have bylaws out at the refuge now.
Okay. Speaking of Denny Null, there's been allegations that you've failed to remain in contact with Denny Null during your time as chairman. Do you disagree with that allegation?
Yes, I do disagree with that. There has been times, Denny usually tries to make every one of our board meetings, which is the second Tuesday of the month. But now sometimes he's had conflicts. He's been on vacations. Of course, he's an attorney, and he has made contacts. And then somewhere in here, he said that I abused my thing there by not bringing Denny Null to the host agreement meetings and things like that. Some of those meetings, I talked to Denny on all occasions. Some of those meetings he thought were just educational. He didn't need to come. Some of those meetings, again, he had conflict. But as I stated a while ago, as we left the refuge, he was part of the committee, and it all got changed, whatever the judge said, September or what, I don't know.
So explain to the court the Denny Null's association with the Refuse Board.
Denny Null Association with the Refuge Board, he is hired as the board attorney all
Now,
the time.
when it was discovered that the Refuse Board would need to enter into a host agreement for this proposed expansion, is that right? There would have to be a new host agreement.
Correct?
Did Denny Null say that, and he's not here, but did he say that he could be the foremost authority on refuse law and he'd be able to provide expert legal opinions on drafting that host agreement?
Not only Denny Null, the county court attorney Jeff Edwards knew that Brian Miles knew more than everybody else on all the committees put together. He said, let's lean on Brian. He can lead us through this. He, like we say, we don't know the waste path and the laws and regulations and stuff like that. So that's where Brian Miles come into the picture. And Denny was all for it.
Okay.
Did Denny know Brian Miles, or who made the first contact with him?
Oh, probably the first contact, I'm not wholeheartedly sure, but probably the first contact was made through Commissioner Cobb.
Marvin, are there minutes of these discussions as far as actions of the 109 board?
What actions?
Forming a committee?
I don't know, Judge, that it was ever put into a motion. We discussed it, and the board said, well, all of us, you couldn't have them all on it, just like you couldn't have all the physical court on it, because you'd have a quorum. So I don't know where the motion was made and put in the minutes, or where we amongst ourselves, they just said, okay, it'll be me and Denny and Tim and Jeremy.
Okay.
And then he said, after negotiation, he would have to bring it back to the board and everybody vote on it.
The reason why I say that is because I know this governing body was advised that the 109 board formed a committee, which when you do that, that means that there's got to be an action taken. And the reason why that's important is because when an action to form a committee is taken, just as we had discussion in here this week, the open record, open meeting laws would apply. So that's why it's very important if you form a committee. Now, officially, the fiscal court didn't form a committee until September 6th of 2018. I believe December 2017, if I remember, was the first conversation piece of needing a host agreement.
That's when Waste Pass sent the letter to Jeremy, I think.
Yes.
The committee was formed thereafter.
Yes, March 23rd of 18
We had a
is
committee by then.
is when we had our informal meeting, and that's because the girls here acknowledged in that that there was a committee formed.
There was.
There was?
Before the March the 23rd meeting from the refuge. And I'm speaking for refuge now.
So from December of 17th to March 23rd of 18, there was a committee formed.
I think, like I say, I can't wholeheartedly give you the dates or anything like that, but I think Deborah might be able to straighten it. Well, did we not have a committee by the March 23rd meeting?
It was understood that there was committee formed when this body, and it was not an informal meeting, it was an official meeting with all members of the Marshall County Fiscal Court together at that meeting, with the exception of Commissioner Boland had to leave, but everybody else was here, and we did have a quorum, and Marvin Stokes, as my understanding was from the refuge board, had decided that Marvin Stokes is chairman, Jeremy Perrin is superintendent, or Jeremy Perrin is waste management coordinator, and Tim Childs as superintendent would represent them. And as the judge said, he and I were the committee members so that no laws would be broken as we met, nor would we disturb or interrupt the negotiations with Waste Path, because there would be no court reporters in there. And the two attorneys agreed on June the 19th of 2018, and it's all on video at a certain mark in there if you'd like to review that since that committee format that negotiated so that the press wouldn't be there to interfere with negotiations or compromise negotiations, knowing good and well that information from those committee meetings and negotiations with Waste Path would have to be brought back to the individual bodies. The judge and I would bring it back to fiscal court, and the county attorney, and Marvin and Tim and Jeremy would bring it back to the entire board, because a committee cannot take action. It has to be by the formal committee, by the formal body, and that's when the attorneys agreed that they did not want to be part of that communication, because they would get all that information when it was brought back to the entire body. But that whole process is very clearly stated in the fiscal court meeting dated 6/19/18. At the 1 hour and 16-minute mark, if you want to save a little time. Don't take my word for it. See it for yourself.
So these are the minutes from December. These are the 109 board minutes. I'll go back to November 14th. From November 14, 2017, all the way to March 13th of 2018, there's no formal action of the 109 board forming a committee. The minutes of the fiscal court for March 23rd meeting, I'm just going to read it because this is the official minutes. The Marshall County Fiscal Court met for an emergency meeting on Friday, March 23rd, 2018, in the fiscal courtroom, Marshall County Courthouse, Benton, Kentucky. Elected commissioners Dr. Rick Koch, Johnny Bolin, and Bob Gold. County Attorney Jeff Edwards were present. Kevin Neal, County Judge Executive, presiding. A motion was made by Commissioner Bolin and second by Commissioner Gold to go into executive session to discuss possible litigation. All voted aye. Motion carried. Judge Neal called court back to order and stated they discussed Rivercrest Engineering putting together a summary for council to look over. Council will then draft a letter to Youngblood Excavating. A motion was made by Commissioner Bolin and second by Commissioner Koch for County Attorney Jeff Edwards to draft a letter to Youngblood Excavating. All voted aye. Motion carried. Commissioner Bolin excused himself from the meeting. Brian Miles, Grant County Solid Waste Coordinator, was present to discuss the host agreement Marshall County Fiscal Court has with WastePath and his recommendations for moving forward. After a very lengthy discussion, a motion was made by Commissioner Koch and second by Commissioner Gold to amend Ordinance 9201, 2% per annum of gross receipts, license fee applicable to off-site waste management facilities located within Marshall County, Kentucky. All voted aye. Motion carried. A motion was made by Commissioner Koch and second by Commissioner Gold to adjourn. All voted aye. Motion carried. No official action to form a committee was taking place March 23rd of 2018. There was no official, from what I can see in the minutes of the 109 board, no official action to form a committee.
Well, Judge, I can just tell you there was a committee formed. I'm not saying that it was a motion or put on the floor of the minutes or whatever. And I cannot tell you the time or the date it was formed.
Right, and Marvin, what I'm saying is that may be the case, but it wouldn't be a committee. If you form a committee, then you have to abide by the open record, open meeting laws. And that's where, by saying that a committee is formed.
I had legal counsel there, and that's all I can tell you, Judge. The meeting was formed. That's irrelevant. I mean, you know the committee was there. It's
When we're looking at possible litigation, it is relevant because you'll have an attorney standing in front of a body arguing if it's a committee or not. That's the importance of it. I mean, we do those things, and those are the questions. You have officials who reviewed the audio that thought a committee was formed in the March 23rd. But when shared with them that no action was taken by the fiscal court, they redacted their statements. Because we just had this discussion the other day about forming a committee. If you form a committee, then you have to record the minutes. It has to be, we have to follow the open record, open meeting laws.
in those minutes from the board, did you get them as written or did you get them off the tape?
I requested them from the 109 board. These are prepared by Jeremy Perrin.
Does a great job.
Yeah.
Does a great job.
Yeah. So it may be, and that lies the part of the problem that I've seen over the course of this is that a committee is not the same as a panel. When we formed our committees, or we had discussion just here recently about forming committees, council's advice is if you form a committee, then there's laws that we have to follow. If you don't call it a committee, then you don't have to have an open meeting, open record. You don't have to follow that. So it's very important that we get that straight.
You stated that the the state representatives believed a committee had been formed pursuant to a letter. Is that correct?
No, an audio.
What was that, sir?
Records the meetings.
Okay.
And I believe they reviewed the audio. I'm assuming that's what they were referring to. Because it wasn't, to my knowledge, it wasn't recorded
So,
by,
so whenever
Denise.
the representatives appeared at that fiscal court meeting, they used the word committee is what you're saying?
which fiscal court meeting?
Well, I understand that a fiscal court meeting was recorded where the state representatives appeared and,
March 23rd or June 19th?
well, I really don't know. You just,
June 19th,
you
I think.
referenced it.
And are you referring to Deborah and?
Yes.
Okay, that was, I believe, June 19th.
Okay,
That was a fiscal court meeting.
okay. And you're saying they used the word committee is what you're saying, when they talked about those four people?
No. I'd have to go back and look at that particular meeting, but in the correspondence, the June 22nd letter from their branch manager to Marvin Stokes states a committee, if I'm not mistaken. And in our conversation, I asked them specifically, if you look at my letter on the second page, number one, please state who participated in a reference conference call February 27, 2018, specifically whether or not Morris County Judge Executive Kevin Neal participated. Please state the date of the Morris County Fiscal Court attended by yourself and Lynn True. Please restate your reference to a committee in reference to the individuals who have been participating and working on the new host agreement. No formal committee has been established by the fiscal court. That was a discussion that myself and council had with Deborah DeLong and Lynn True, and I believe that was when it was stated that they reviewed the audio. So I'm assuming that it's this because
Okay.
we did not film the March 23rd meeting.
Okay, and then that,
Would that be accurate? Okay, then what, okay.
may I ask, but then you asked that information be retracted, and that was retracted, correct?
It was retracted.
Okay, including the reference to the word committee.
Yes, they retracted it.
All right. Any other questions, or may I continue? So, Marvin, speaking of this conference call, can you explain why you didn't correct the information that you were not a participant in this conference call?
I couldn't correct anything. I wasn't part of the conference call. I wasn't on it. And I heard it at the same time that Judge Neal, so I couldn't.
Well, when it was referenced that you were part of the call, is there any particular reason why you didn't correct that information at that time?
Wasn't going to correct it. Didn't know anything about it. There's nothing, I hadn't been in on it, didn't know anything about it.
Two more questions. Was there ever a time during your tenure as chairman of the refuse board that Rick Cock refused to leave a meeting of the board when it went into executive session?
Absolutely never.
Is there any truth whatsoever to that allegation?
None whatsoever. If I'd asked Doc Cock to leave it when we went to executive session, he would have got out. And I was saw to it.
It's the only questions,
Unless-
I'm sorry, go ahead.
Okay, unless the board had asked him to stay, and he never refused to leave, period.
All the questions I have for Mr. Stokes.
I have a question. The judge's letter to you references a phone call made by Dr. Cock to Commissioner Boland. You know what I'm talking about, right? Or Commissioner Lamb.
Is that the phone call? What was the question again, Jason?
Well, his letter references a phone call made by Dr. Cock to Commissioner Lamb. You know where I'm referring to in the letter.
No.
Did you know anything about that phone call?
Did I know about the phone call? No.
Did you know he was going to make the phone call?
No.
Okay.
Had I talked to Dr. Cock about what the judge had talked to me? Yes. I extend it.
What phone call are you referring to?
The one that's in the letter, referenced in the letter to,
Assume that was
The morning of February 5th.
February 5th.
it wasn't February 5th.
It was January.
It was the
14th at 2:05 in
morning
the
we had the
afternoon.
executive session.
It was in January. Yeah.
January 14th, 2:05.
I apologize, it wasn't February 5th.
January 14th, 2:05. You want me to answer your question, Jason? I can answer your question.
No,
Okay.
not now anyway.
I've got a couple. Do you know how long it's been since we've had a host agreement?
The host agreement, I think, expired January 1 of 1994. The green box, the best I can go back in history and find, the green boxes was started when we got the host agreement July of 92. And then I think all of it expired January 1 of 94, except the ordinance pertaining to the fiscal court, which the refuge and original, and I have the original host agreement. In the original host agreement, we got 300 tons a week. 200 a week, free tipping a week at the refuge. And then after that was dropped, which whoever dropped the ball, we didn't get the free tipping. All total this year, our 2017-18, it cost us right at $300,000, $249,000 to Waste Path and some to Mayfield. But in the original host agreement, the refuge, the city, the citizens of this county got free tipping at LWD at that time. It was not Waste Path. And it expired January 1 of 94, at my recollection. And then the county continued to receive their 2%. But the refuge didn't get anything.
That's why these ladies from Waste Management are here, the foremost authority in the state of Kentucky on the language of waste management and the laws that pertain to it are here on Marvin's behalf too. And that's why on March 23rd, we involved those people because of their own admission. County Attorney Jeff Edwards and Refuge Attorney Denny Null knew nothing to be ashamed of, nor did the commissioners, nor did the judge, nor did any members of the Refuge Board, including the superintendent, waste management coordinator, have any knowledge of the language or the law of waste management that concerned waste management, pertaining to waste management. So we identified a person that did through contacting waste management in the state of Kentucky. They sent us a model ordinance from Grant County. Thus, the waste management coordinator, one of the foremost authorities recommended, has gone through this process with several counties and helped them. Came on March 23rd out of the goodness of his heart, no charge. We paid him a hotel room and mileage to get down here because we wanted to get this thing right. Our mission statement in Marshall County is to protect the environment, health, safety, and welfare of the 31,000 people of Marshall County, and we wanted to do it right.
In your opinion, why hasn't a host agreement been executed to this point?
Because we've never had enough sit-down talk with Waste Path to get a host agreement. That's my opinion. It's not because of lack of correspondence on my part. Waste Path, but you know, they don't want to sit down and talk every time. And some of the times Judge Neal's talked to them.
And Kevin, it's my understanding that it wasn't until about October that we identified that actually under the state constitution, chapter 142, I believe, it has to be bid. That was found out months after when all the negotiations were going on, and it was I believe that, I don't even know where that came from. Jeff showed up one day, I think it was Waste Path's attorney that actually had okay, so it came from Mr. Miles, but that information came months later that it has to be bid. So I think that's probably a more accurate response to your question, is that we had to bid it. We got to bid it. But it took us months to figure that out. And I don't know where Mr. Miles, he's here, I'm sure he's going to get up and speak, but
He is.
I don't know where he got that information at, but I know when Jeff contacted him, because our question was, how do you bid a service that the provider owns? And Mr. Miles had apparently documents on how to bid that process. So I don't know if that was, I'd like to hear from him because I've got a question for him too. But in October, I believe, is when we identified that we have to bid it per the state constitution.
Anything else from me?
No, sir. Thank you.
I would like to ask Brian Miles to speak. May I proceed?
Yes.
I guess for formalities, would you state your name, please?
Brian Miles.
And Brian, how are you employed?
My employed is the Director of the Solid Waste Management District and the Solid Waste Coordinator for Grant County, Kentucky.
Okay, and I apologize, I know this isn't a court of law, but I'm used to being in a court of law, so my question and answer format is all I really know. In your capacity in that employment, have you received any sort of education, specialized education to put you in that position?
Yes, I'm an environmental scientist. Grew up on the farm, worked environmental work all my life, hazardous waste work. When I entered the solid waste field 20 years ago, my judge executive approached me. I had never gone to college. And he said, Brian, he says, we have a tuition reimbursement program. I want you to go to school. So for the next 12 years, from 2000 through 2012, I attended NKU, and I received my degree in environmental science with a minor in geology and a minor in geographic information systems.
And just explain what your experience has been, your work experience.
Now, I have been the coordinator and director for 20 years of the Grant County Solid Waste Management District. We do have a landfill in the county. I've negotiated several contracts, several host agreements with our own landfill. I've assisted a couple other counties in negotiating their host agreements. My board chairman is he was an environmental attorney. He practiced for 30 years, and he helped me out with it, and we would talk with other counties and help them.
Okay. So we've talked a lot about host agreements, but just, I guess in layperson's terms, can you explain what a host agreement is as it pertains to our discussion today?
A host agreement lays out the entire understanding and agreement between a landfill and the host community as to how that relationship is going to go down. What fees are going to be paid, what protections are offered, inspections, communication issues, all that type of stuff. Everything having to do with protecting the residents of the county that the landfill is located in is contained in that host agreement.
Okay, now, through your experience, your education, is it fair to say you are knowledgeable on the laws, regulations, and policies surrounding landfills, waste management, and everything involved in that?
I believe so. I've dealt with it successfully for 20 years, but whether you're qualified to speak about it is what other people say about you.
Sure. Now, you've been involved in this process of negotiating a host agreement for Marshall County.
Yes, I have.
How long have you been assisting Marshall County in that process?
I received a call, I'm going to say probably February of 18, somewhere in that time span, from Dr. Koch. They had just found out they were going to need to go through an expansion and a host agreement process. He had contacted some people at the state. The state gave him my former judge executive's number as this is a county that got it right and has got it going on. He contacted my former judge executive, and the judge gave him my number, and he immediately contacted me.
Okay. Were you provided any compensation for your time and services to Marshall County?
When I come down here to work, and we discussed it at the very first joint meeting that we had with the fiscal court and the representatives from the refuse board, they would take care of my hotel, they would take care of travel expenses. As far as compensation for work being done, no. My only concern was to make sure that I safeguarded the residents of the county, therefore the residents of the state. I knew that there was, and I'm not, please don't anybody take this as a personal insult or personal slam. I knew that the level of experience and knowledge as to what they were dealing with here, they just didn't have that experience. They needed some help. That's why I offered to step in at no charge to do it.
So there was some discussion earlier about Jeff Edwards, who was the county attorney, learning that the host agreement process had to be put to a bid. He got that information from you.
Yes. We
So-
did,
Yeah.
as a group, and I believe this was actually after the actual committee was formed through the court. I had put together a draft agreement. It had been, we went through the entire group. The attorneys got together on the legal language, told us what they wanted in there legal language wise. The group, everybody agreed on all the other terms that were in the host agreement that, okay, this is our starting point. We knew it wasn't where we were going to end, but this was where our starting point was. We got the draft put together. Everybody was okay with it. We shipped it off to Waste Path. Okay, here it is. Here's the first draft. Look it over. Get back to us with what gives you heartburn, and we'll sit down and talk about it. Basically the way things go. The response that I believe the judge and the fiscal court got back, I think they sent you a letter with the response on that first one.
Who?
Waste Path.
I believe the letter was addressed to the chairman of the 109 board, CC'd to me,
Okay, all right.
but I read it off in court.
Right, you read it off in court. So we knew we had a response back from them. And one of the first things that their legal counsel did was said, okay, let's not call this a host agreement, because if you call it a host agreement, it has to be bid, so let's call it an agreement. Well, I did some checking, and, part of this piece of it may have been a little bit of lacking on me. I'd had a stroke and a heart attack in between all this happening. I had simply forgotten that in 2007, we went through the same thing in Grant County. The attorney came in and said, look, you got to bid this. So we went ahead and bid it back then. It is the same attorney who is representing Waste Path now. So Jeff Edwards and I talked, and I sat back and I told him, Jeff says, what do you think? And I says, well, you have the BFI decision and you have the Arnett decision. Both of those are Court of Appeals cases that took place. The specific issue of bidding the host agreement was never ruled upon by the courts. But in a footnote in the judge's decision, he mentions this and he sits back and says, this is something that needs to be looked at because it probably would not stand up to constitutional muster. That's in a footnote. So Jeff and I talked about it. I emailed Jeff the cases. Jeff came back and he says, and this was late October, early November. He says, all discussions with Waste Path stops. End of discussion. Till we get these legal issues figured out, everything stops. Okay, I'm on hold from the county attorney's directive. What ended up happening was in later conversations between Jeff and myself, he said, this court ruling really sucks. And I said, yes, it does. It's a bad ruling. It's written bad. And for the exact same reason that you, Judge, mentioned. How do you bid something out, a service out, when the person owns the land and is performing the service? unfortunately, that doesn't make any difference. The legal system, the justice system ruled, and the Constitution comes into play, and it's the granting of a privilege, it's the granting of a franchise. It has to be bid by the Constitution. That was, after those conversations with Jeff, that was pretty much the last thing I heard about host agreement stuff until I get a call that, hey, the refuge board's opening a bid. I didn't know anything about it.
Okay, so I think the members of the court can pick up on the fact that the refuse board and the attorneys involved in this process, even the attorneys look to you for guidance as it pertains to legal matters surrounding this issue.
Yes. I took many calls from Jeff Edwards and Denny Knoll both.
Okay. With legal questions?
Just asking me different things, is this an industry standard or is this a statutory requirement?
Right.
Those types of questions.
Okay. Under Kentucky law, what governing body has sole control over operations of a landfill?
Well, I'll actually go a little bit further than that.
Please.
What the statute reads pretty much in summary is once you form a district and then you place a board, all powers, duties, and requirements of the fiscal court transfer to the 109 board. So all duties, all management-related issues for solid waste are under the governing body control of the 109 board.
So then, what governing board in Marshall County has the sole authority to enter into this host agreement?
That would be the 109 board, the refuge board.
Now, I know, I'm going to ask this question, but I know you're going to elaborate. Because the 109 board has that authority, is there any requirement for communication between the 109 board and the fiscal court?
Requirement, no.
Please elaborate.
The 109 board, as the governing body, has the authority to enter into any contract with any person for any number of years, having anything to do with solid waste management related activities. That pretty much covers everything. They don't have to, a 109 board, let's say the ordinance is going to read, I want to do ABC. Let's just put it clear out in hypothetical land. The 109 board has the sole authority to sit back for Marshall County and say, we are going to require ABC be done. They don't have to discuss it, have a resolution, anything like that, and we'll come back to the fiscal court for it to be memorialized and finalized. The decision of the 109 board is the final decision.
How involved would you say you've been in this process over the last year with Marshall County?
As involved as I was allowed to be.
And can you estimate how many times you've been to Marshall County to assist in the process?
I'll say 5 or 6 trips maybe.
Okay.
And then, of course, countless phone calls, some emails, things like that.
During the course of your involvement in this host agreement process, are you aware of any delays in the negotiations for that host agreement?
Yes.
And in your opinion, as an ongoing part of that process, does any blame for these delays lie with Marvin Stokes or the 109 Refuge Board?
No, sir. Absolutely none.
In your opinion, what is the reason for the delays and inefficiency for that host
Well,
agreement?
what has occurred is, and again, not trying to put anybody down, not trying to upset anybody, because of the experience level of everybody involved in the county. Hadn't been through this before. Never knew, didn't know what needed to take place, how it needed to happen. I know this is going to sound self-serving, but I don't mean it to be. The smartest decision the folks in Marshall County made was to go outside and find other people, whether it was me or somebody else. There's a couple other folks with my experience in the state. Smart decision they made. We don't know exactly what we're dealing with, so let's go find the help. And that search came to me from Dr. Cock and Marvin Stokes. So what ends up happening is, in the whole first part of this, and the other side of this is the landfill didn't know what to do either. They had never been through the process. They're a one-facility landfill. They don't have 18 facilities across the state where they've done this 18 times and it's a template cookie cutter thing for them. So you had all of these folks who really hadn't been through this before trying to find their way through. You had a few folks come in, I came in, the state came in, and we try to help guide them. Okay, this is what you're looking at, this is what's going to happen, this is where it's going to go, back and forth, this is what you have to do, this is what you may want to do, those types of things. So through the first part of it, it was determined that the landfill never actually submitted the proper paperwork to the state, or to the county, to request the expansion. An NOI has to be submitted. Never was. So that's the first delay that took place in this. Second delay that takes place in it, and it kind of blew everybody out of the water, was the host agreement that was presented at the May 15th meeting. I don't know what the distribution list says, but I didn't get it. As the person trying to lead this crew, I didn't get it. When Jeff Edwards was questioned in the meeting about it, when it all started blowing up, he says, "No, I didn't send it to you. You're not an insider. I didn't send it to you." Okay, fine. Now we have to deal with this problem because we have a host agreement that was based on, from what Jeff says, the Graves County agreement. There was an old expired agreement from 15. Graves County doesn't have a 109 board or a district, so it really wasn't relevant, so they tried to mishmash everything together. Was a bad outcome. So that ends up being a second delay. The third delay happened upon WastePath submitting the bid submitting the response to the original draft host agreement we sent out, saying, we can't call this a host agreement. Jeff Edwards, rightfully so, steps in and says, everything stops here. Till we figure this out, everything stops. So that happened late October to early November. It's been delayed ever since then until I got the call, I think it was last week. I got the call that WastePath had sent a bid in, and I says, okay, did you public notice it? Yeah, well, let me send me a copy of the public notice. They did. And I got to tell them, they got it right. The public notice was correct. It was one that I had written back in 2008. Just the process, the communication has been disastrous through this amongst all the parties involved. You know, I'm not being notified of stuff. I'm not being talked to. You know, refuge, not talking to court not talking to refuge. It all comes down to the fact that the refuge board it's where this footprint ends. The refuge board is have to make the decision.
During your time assisting Marshall County with these negotiations, you had a lot of contact with Marvin Stokes.
I did.
Okay. And in your opinion, was he ever inefficient in any way?
Absolutely not.
Was he ever non-communicative in any way regarding the process?
Absolutely not. When something would happen, Marvin would call me and say, Brian, this is what happened. Should I have expected this? Is this out of the ordinary? Marvin's communication with me and trying to help him get through this, it has been no inefficiency and no delays. It's been to try and understand what's going on and move the process forward. And given the delays that we have experienced that weren't a direct result of 109 board issues, you know, none of them, as far as I'm concerned, were a direct result of that. If you take those time periods out, the response time that the refuge board has had to the requests from the landfill that have come to them for action has been handled very quickly and very efficiently.
Okay. And you mentioned earlier that you've helped some other counties do this similar process. Do you know how many off the top of your head?
There's one that I actually wrote the draft host agreement for, and the attorney went ahead and took it and negotiated the final, and then he made the changes to the draft. There's language in a host agreement that I have written in probably 7 or 8 counties host agreements around.
And so have you communicated or had experience with other chairmen of 109 refuge boards?
There's very few 109 boards statewide.
Okay.
Yes, I have talked with a few of them.
Okay. So in your experience with other boards, in your experience with Marvin, do you consider him ineffective as chairman of this board in any way?
I do not consider him ineffective, no. Marvin, more than most. Most 109 board chairmen, when they end up faced with a situation, it's like, okay, I've got to make a decision, I'm going to make a decision. Marvin, more than anybody else, he would call somebody and get some guidance on it. And it's, hey, this is the decision that I have to make. What's the pros and cons of it? And that's just the facts of this.
I have no other questions.
Excuse me, I've got a question. How many host agreements would you say you've been involved in negotiating?
Actually involved in negotiations, two others outside of my own county. My own county, we have written 4 in my last 20 years.
And what would you say would be the average time from beginning to end to getting the host agreement signed?
We have had host agreements that have taken up to 2.5 to 3 years to get them finished. And we've had host agreements that have been finished in 10 days. You know, if you have a landfill that has a host agreement and they need something, they need a change to one of the terms in the host agreement, they need a permit change of some sort, you can get them back to the table at that point in time. When they come back to the table, if it's only a couple little issues that you're talking about, that could be a 10-dayer. When you get into a situation like this, there's been no host agreement in place since '94. Yes, they've continued to pay the 2% to the county, the fee, but there was no host agreement in place. That means there was no limitations on service areas. There was no protection from environmental liabilities, environmental risk to the county and the residents. There were no benefits other than cash to the residents of the county. Most landfills give free disposal to a certain amount to somebody. In this case, we weren't able to make that happen, but, well, as it stands right now, we haven't been able to be successful with that, but we're still talking about it. And I think there's some middle ground there that we can live with, because at our very first meeting, back in March of 18, I think
March 23rd.
March 23rd of 18, I asked those specific questions. I says, okay, you have a small landfill company, you have a landfill company that isn't a financial powerhouse that can give you whatever you want. What are your expectations? What are you looking for out of this? And they gave me, the group sitting here in this room, gave me some guidance as to what types of benefits they were looking for. And so that was our starting point to go from there.
So, let me just understand this. So what you're saying is that the 109 board has all authority to do this?
Yes.
So in those those times that you've been involved, whether it's in Grant County or any other county, did the fiscal courts get involved in that process? Are you telling me that in each one of those fiscal courts stayed out of it? And the 109 board did everything, and there was no, and you just came back and said, this is what we did?
I will tell you exactly what happened in Grant County. Okay? Landfill wanted a new host agreement, so they wanted some changes. They wanted an expansion. They came to the 109 board meeting. 109 board says, okay, at 300 cubic feet of gas per minute, methane being produced, or landfill gas being produced, you can run a generating set, and you can generate electricity and recycle that gas. So we were at 1,200 cubic feet. We could run 4 or 5 engines off the amount of gas they were producing. The one hard and fast thing that my 109 board said was, if you're going to expand, you're going to put in a gas to electric generating plant, or you don't get the expansion. Landfill didn't like that. Didn't like it at all. The president of Republic Services went to the judge executive of the county and sat back and said, those guys are out of control, those guys are nuts, we want nothing to do with them, blah, blah, blah. You need to make something happen. My judge executive sat back and said, no, they're the governing body. You go talk to them, you make them happy, then they'll bring it to me. My county was that way. Elton County, that I helped the negotiations over there, was the exact same way. The fiscal court does not interfere in the business of the 109 board.
But at the end, you did say, what that judge executive said was, you go do it, but, and then
Because in our
bring it
county-
back. Are you,
In our county,
what
I
I'm
did say
hearing
that.
you say
In our county
is,
at the time, the ordinance read that the 109 board did everything with the exception of final approval of X, which was the expansion. We had never really looked at the statutes because we never had a problem. Fiscal court and the 109 board never went head to head. They were always walking in lockstep. So we got to looking, and we found the statutes and the statutory language, and the ordinance that the county passed that says all management powers and duties are transferred to the board with the exception of was repealed. All 4 of those issues went away once it was identified that the statute was there.
and our ordinance says, or do we even have?
We have an ordinance.
Does it,
I believe it's a 1992, 91 ordinance.
See, in 92 and 93, what happened was REPRA passed the federal government in 76. All the REPRA standards, or all the REPRA laws, which is what governs solid waste management facilities, it had to take effect by either 93 or 94. So in 92, 93, there was a whole lot of activity going on with landfills getting stuff in place, getting their paperwork in place, and host agreements and this and that, just all kinds of stuff taking place in that time period. Every county in the state that has landfills in that same boat.
yeah, and our particular ordinance, does it have?
We can pull that up. It's a.
Just wondering if it has something like what he's talking about, where, I mean, just as a point of reference,
That being stated in.
I would
the
say
creation
from
ordinance
91
for
to now, it's
Marshall County.
probably needs to be
109
updated. Brian, I got one quick question for you regarding that ordinance, because on August 7th, you stood here and said that you had one change to the ordinance that was presented for the first reading. Jeff?
Was that on the 5%, 2% ordinance?
Yeah, hang on though. But that change was made. Jeff made that. He corresponded with you because the ordinance is the fiscal court. Only the fiscal court can pass that ordinance. So on the 7th, the second reading of that ordinance, you apparently contacted Commissioner Cock and told him, do not vote for that ordinance?
What I said was, the ordinance cannot be passed at this time because it wasn't ready. When you mesh together refuge board, 109 board stuff, and county ordinances, you really have to have the proper timing, or you get yourself into trouble. That ordinance that you're speaking about, at the March 23rd meeting, I said, y'all are going to need to pass an ordinance to make this happen, but the ordinance comes after the host agreement.
Actually, let me interrupt you real quick. The March 23rd meeting, it's in the official minutes that they voted to amend that ordinance. So
I'm not sure how that happened.
August 7th, we took the initiative to amend that ordinance. You were here. You said one change and it looks good. September 6th, you contacted Commissioner Koch and told him, do not vote for that ordinance. Now, the reason why I bring that up, and I agree with you, that there is some overlapping relationship between the host agreement and the ordinance. But the problem I have is that when you say that there's this going on, now think about that. You say that the ordinance is good to go. It's approved and it's in the minutes from March 23rd, and then on September 6th, I preside over the fiscal court, and that's been, and you and I, we've talked. That's been my chief complaint. It may be the 109 in dealing with the host agreement, but the 1992 host agreement, who signed it? Judge Executive. That's right. So the host agreement that the Graves County has, Judge Executive signed it.
Graves County doesn't have a 109.
They don't have a 109 district, but you can see where that confusion is now.
Oh, I understand.
With your expertise, okay? March 23rd, when the court voted, or the official minutes show that that's what was to happen. That was the wishes of the fiscal court. And by statute, the wishes of the fiscal court is not a commissioner. It's my responsibility. Because again, if an attorney is called in and I'm called in front of a judge in a judicial situation, I'm the one that has to respond to that. So the carry out the wishes of the fiscal court is my office with counsel. But when you called Commissioner Koch and told him not to vote on that ordinance, don't you think that's kind of bypassing the process?
I never said, do not vote on something. What I said was, we are not ready for that ordinance to be passed, and you can get into legal trouble with it.
Mm-hmm.
If you sit back.
No, let me ask you, and that's fair, that's fair. But what?
If you sit back and you pass an ordinance, and you say, I'm going to charge an apple for a ton of waste, and you know that there are other facilities in your county who are going to be affected by the ordinance, not by the host agreement, okay? You can't go to those other facilities and say, I'm going to charge you 2 apples for that ton of waste that you're taking in, because then you're going to get sued.
Yeah, and let me just say, I understand that. We've had, to some degree, those conversations. But my point is that there's a process. We're talking September of 2018, okay? Now, this initiated back in December of 17. For the host agreement, that's the 109 district. And that responsibility falls, in my opinion, on the chairman, because that was identified. There's got to be a host agreement. We get into September, and we're still bypassing the process. And let's be clear, I've made it clear, but when you call a commissioner, he doesn't carry out the wishes of the fiscal court. And you and I have had these conversations. In some of our meetings, I've made it very clear. Hang on.
And asked me an opinion about whether something is ready to be passed or not. I'm going to answer that question. And that's exactly what happened.
Well, then let me, and that's great. I'm glad we got the opportunity to have this conversation, because then what was presented in court was that the commissioner was contacted by you.
That is inaccurate.
That's not inaccurate. My point, here we are in September, okay? I'm not going to disagree with the knowledge of the material in these documents, but the process, there is a process. We've had these conversations. I've made it clear to all three of you that if we follow the the meeting that we had in Calvert, that was the first time, in my opinion, that we actually got it right. And if we're gonna move forward on negotiating, and I even,
Okay, so let me ask you from that point on. I agree with you, that was a great meeting. We had a host agreement on the computer, we had it up on the screen, everybody was there. Everybody in the group was able to sit back and say, I like this, I don't like this. We came to a consensus on the language. There were 2 items left for the attorneys to do the language for. They put that together. I inserted it to the document. I send it out to the entire group. The entire group says we're good to go. I send it to Waste Pass. After that, Waste Pass response to us triggers the bid process. The county attorney, nobody else, the county attorney, it represents the fiscal court, sat back and said, that's it. We're done. Nobody talks to anybody. There hasn't been any,
yes.
which is the correct thing to do.
Yes, yes.
And there hasn't been any communication with anybody since that point in time, and now all of a sudden the bid's coming in. Yes, I agree with you. Communication is a problem.
Well, what I'm saying, in your narrative that you just described, you left out a whole host of information from December all the way up to those dates. The point is that there's a process, and when you stand here in front of the governing body saying that there's this 109, you referred to your county and how you worked with your issues in your county. But you referred what you were saying just a few minutes ago as far as the 109 and the fiscal court is what I'm assuming. But in September, we still have that. And that's the core of this issue. It's not the material. You can stand up here and by all means, I've listened to you, and there's stuff that you know, but we disagreed on the state constitution as far as the 20-year term, even though that there may be a 109 law that requires to go beyond 20 years. If it's challenged, you defer. I'm just stating.
I sat back, I want to make sure we're clear on this. I sat back and I identified both sides of that, and I said, y'all can pick either way you want to go, but this is where your problem's going to lie.
I'm just saying, I voiced my opinion that if the state constitution says 20 years, we follow 20 years. You argued that it hadn't been challenged yet. I don't want Marshall County to be the one to challenge it. So that's.
I argued that it hadn't been challenged, and there was a statute that competed with that, but I also offered an ordinance to take care of that problem. I submitted it to both attorneys. Did you get that?
Yeah, no, I wouldn't even entertain that. 20 years, the state constitution, I made that very clear, that was my position. If we're gonna go into a contract, it's gonna be 20 years.
So you're okay with granting a landfill enough tonnage to operate for 100 years, but only guarantee the protections to your residents for 20 years?
If the state constitution says 20 years, yes. I'm gonna err on the state constitution, yes, all day. Legislature's passing the statute. I would rather put my money on the state constitution. And we've had this conversation, but we've kind of got off of that.
We got off of the purpose.
But you've identified. Go ahead, Jason.
Oh, sorry. I do have one question, and this kind of dovetails on what Commissioner Collins asked you about your prior involvement with dealing with 109s and fiscal courts. In this particular situation, the involvement of one of the commissioners, previous commissioners of this court, was that unusual for you to see a commissioner that involved in the process?
No, it's not unusual. Matter of fact, normally I have all the commissioners or magistrates calling me. You know, if there's 3 magistrates or commissioners in a fiscal court, and I'm assisting them and trying to get through this process, I generally end up with all of them calling me at least once.
Now, I'm gonna ask a question that I always ask everybody. Are those action items that all of them are going to talk to you about? Are those action items?
Oh, yeah.
Then you're actually in violation of the open meeting, open record laws. It's a continuation of a quorum. And I'm just.
Every member doesn't have the same question.
I'm just saying, though. The thing about this whole procedure is that here we are. You stated that sometimes it takes 10 days if it's a county that has a host agreement to where in our case. You're kind of comparing us to other counties. We're totally unique and different
Exactly.
and to some degree.
Exactly.
I feel personally that
You're
this.
starting from square one.
I feel that we could have got a host agreement together from the 109. It could have been bid out procedurally the right way. I mean, in your experience of expertise, you have knowledge of that, but 10 months in, I'm just going to be honest with you. I have a hard time that you've got a lot of knowledge on other subject material, but a bid, that is very huge, because if there were 2 or more that bid for this, we'd be looking at a lot more legal issues, just like the Franklin County.
I'm not the one who sat back and put the ball in motion that it had to bid. That was the appeals court.
No.
And that's the Constitution.
No, what I'm saying is the details of the conversation, okay? If you're being paid to consult the 109,
Which I wasn't being.
the court's paying your travel.
Paying my travel.
The court's paying your travel to come down and consult. Putting all the eggs in one basket, and that's a very important piece to just not remember or forget that your county went through that process. I mean, to me, I think that that would have been a known item that it needed to be bid.
Well, it happened in 2007. In March of 2012, I had a massive brain bleed and a stroke. And for about 10 years prior to the date of the stroke, I have no memory at all. That is why there was no memory of it happening. That is why when Jeff called me and said, this is what they had responded to us with, and I started looking through it, and I started looking through my documents, I find the bid document. So it's not that I'm an old senile man and I just happened to forget this. No, there's 10 years of my life that I don't remember because of the stroke, and it was in that time period.
I have a question. I'd like to bring us back to the reason we're here. This call in September between you and Rick Cock, what did that have to do with Marvin Stokes?
Absolutely nothing.
That's all I have. Any questions? Thank you, Brian.
Thank you all.
There's 2 representatives here from the state, Deborah DeLong and Lynn True. I would like to ask them to speak. May we take a break, please?
Sure, go ahead.
I just asked Deborah DeLong and Lynn True. I don't even know what you're with, so you can introduce yourselves, but I'd like to ask them to speak. They've prepared a statement.
I do have a prepared statement for the court, but I also will answer questions afterwards. So good afternoon, ladies and gentlemen. I am Deborah DeLong. I'm an environmental scientist 4 with the Energy and Environment Cabinet, Division of Waste Management. We are a regulatory agency, and throughout Kentucky, we manage waste management and are in charge of overseeing the management of waste throughout Kentucky. My purpose here, my sole purpose here, okay, is to provide information that is relevant to any changes in the function and/or structure of your 109 District Board. As a local assistant tasked with determining compliance for Marshall County and providing assistance to the governing body of the Marshall County Solid Waste District, it is imperative that I am kept informed about any changes and developments that may require a plan amendment to your solid waste management plan. So with that being said, we represent the state. We represent compliance, statutes, regulations, policy, and procedure of the cabinet. We do not represent any landfill. We do not represent any county local official. We are a regulatory agency. So I noticed, Judge, you said that I came with Marvin. I did not. I came because this is pertinent to your waste planning, okay? So for reference and clarification of the statutory authority of the cabinet to coordinate the activities of Marshall County Solid Waste, please refer to the Kentucky Solid Waste Planning Statutes found in KRS Chapters 224 and 109. I have copies of those in a folder for you. A summarized statement of solid waste planning statutes are listed below. KRS 224.43-3101 defines our agency's authority. The Energy and Environment Cabinet of the Commonwealth of Kentucky is designated as the official planning management agency of the Commonwealth of Kentucky in the field of solid waste. The Cabinet shall have primary responsibility for coordinating solid waste planning and management activities of waste management districts, counties, cities, area development districts, any combination thereof, and for the approval of solid waste management facilities. In doing so, it shall be the goal of the Cabinet to reduce the amount of solid waste disposed in a municipal solid waste disposal facility within the Commonwealth and to encourage regional management of that solid waste. KRS 224.43310 designates our agency as the official planning and management agency for statewide solid waste management. The Energy and Environment Cabinet of Kentucky has the primary responsibility to coordinate area solid waste management plans and provide support for planning efforts. Through education, information, site visits, guidance, we assist local officials with compliance requirements for managing waste on the local level. The primary goal of the Cabinet is to reduce the amount of solid waste disposed, in municipal solid waste facilities within the Commonwealth. To achieve statewide, regional, and local goals, the Cabinet coordinates the activities of waste management districts, counties, cities, area development districts, and any combination thereof for the approval of solid waste management facilities. This oversight includes assisting local government in achieving compliance with state and federal laws and regulations in regard to the reduction, collection, transportation, and disposal of solid waste in their area in a manner that's going to protect the public health and the welfare, prevent the spread of disease and the creation of nuisances, conserve our natural resources, and enhance the beauty and quality of our environment. KRS 224.43-3106 finds that the counties and districts, when enabled with accurate information related to municipal solid waste collection and management practices within the solid waste management area, are in the best position to make the plans for solid waste collection for its citizens. In accordance with statutes outlined above, our task as Cabinet employees is to educate and inform all counties in regards to the design, development, planning, implementation, and evaluation of all waste management practices in their area. This includes, among other things, implementing solid waste management plans, planning for disposal capacity, siting solid waste facilities, complying with local determination, and reporting of authorized capacity on an annual basis. It is important to note the Cabinet does not interfere with local decisions or political issues, but we simply provide educational materials and information so that decisions for waste management can be made by the local authority and governing body of the solid waste management district. The Cabinet recognizes local authority to manage solid waste in Marshall County as the 109 Board, KRS 109, as determined through your ordinance as well. As such, pursuant to KAR 401-47-160, upon being notified by the local authority, the 109 Board, of a proposed expansion for the contained landfill waste path in Marshall County, the Cabinet has offered assistance and guidance for the local determination process, which is a statutory requirement. Pursuant to 401 KAR 47-160, the permitting process begins with local determination. In lieu of ongoing negotiations with a draft host agreement, local determination is ongoing. Be advised, any change in the Solid Waste Management Authority, 109 board members, chairmen, will require a plan amendment in your solid waste management plan. Any decisions or action taken in regard to the 109 or solid waste planning shall be communicated immediately to the cabinet before any further solid waste management action can occur. You want to ask a question?
Anybody have any questions about that? All right. Deborah, through your employment, have you gotten to know Marvin Stokes?
Marvin Stokes is the 109 Chair Board member of chairman of the Marshall County, and he is the one solely responsible for signing the solid waste management plan once it is completed. He is the one that implements that plan, and he is the one who reports to us annually to make sure that your county stays in compliance. Marvin has increased recycling. He has managed to meet compliance goals of the state to divert waste from the landfill, and maintains good communication and records with the county and with us as far as county records go.
Okay. In your experience with Marvin, has he been, to the best of your knowledge, has he been fully compliant as the board chairman with all statutes, regulations, and policies?
Marvin communicates with the state on a regular basis with statutes and regulations. We have had trainings here in Marshall County and phone calls from Marvin to explain the statutes and the regulations and procedures. He has followed each one to the letter. In terms of local determination, WastePath had sent a letter to the county back in December of 17 that only had a capacity number on it, and they asked for expansion. At that point, I contacted Jeremy. The cabinet was known. Marvin let us know. We contacted Jeremy and Tim Childs, and we discussed a need for some educational material on local determination. That is a 4-part process that takes at least 6 months to complete. Marvin was not in on that particular phone call. This is the conference call that's been referenced. The conference call was between myself, my supervisor, Lynn True, Tim Childs, and Jeremy, and, excuse me. We discussed at that point, it was a 10-minute phone call about the need for local determination and how that process is going to work. And in a minute, I'll talk more about that. And the need for a host agreement if that's something the county chose to do. Your host agreement had expired, and now's the opportunity during an expansion to come back to the table, rework terms of the host agreement, what's correct for your county as far as tipping fees, money that you might want to gain, and have an agreement with the landfill that will benefit the landfill and the county to protect the environment and the residents of Marshall County.
Okay, so, you know, again,
We're going to talk more about that. Do you want me to?
Yeah, go ahead, please.
Okay, so we had the conference call, and through miscommunication on my part, I was with the understanding there were more people in the room than what was there. It was truly Tim and Jeremy. So when the judge had talked to me about that, he sent me an email through Jeff and asked, please state who participated in the reference conference call. In that, I responded that it was Tim, Jeremy, myself, and Lynn. And I said specifically, no one else was in on that call on my response. So he knew at that point Marvin was not in on that call by my response. Second question, please state the date of the Marshall County Fiscal Court meeting. The letter that he read that I sent earlier misread the date as June 26th. I corrected that date and said it was a June 19th fiscal court meeting. Please register your reference as a committee. I redacted the word committee based on his request and stated that the cabinet would not recognize any committee not appointed by the court or by the 109 board and would not take action on anything a committee until it was appointed gave to us. So at that point, until a committee was chosen, any communication was not part of any decision-making based on that. So that's how we redacted those. I have the letter that he references. And because Marvin was not in on the call, he had no idea of the content of the phone call. But we put it into the letter, and we copied Marvin, and we also copied the judge and Jeremy. Okay? And in the conference call, the whole point of mentioning who was in that conference call simply was an introductory paragraph to the letter. The meat and potatoes of this letter goes on to say that we want to have, in order to facilitate the whole process, we will arrange for a meeting with the original committee that was formed on March 23rd. This is why I redacted the committee, because he said that no committee had been formed at that time. Now, when we talk about this letter in terms of the fiscal court meeting that we attended, the letter that he says with Marvin, on February 27th, Deborah DeLong and Lynn True conducted a conference call with the solid waste coordinator and Tim. This was confirmed meeting with Jeremy and Tim, and then I redacted all that. Deborah DeLong stated in an open fiscal court meeting that she spoke to me, you, Jeremy, and Tim during this conference call. During that fiscal court meeting, I was not allowed to speak. That was not me that said those. So this statement here is wrong. The letter that you received from WastePath on that, the letter proposed an expansion and requested consistency determination from the 109 board. He said that Marvin was present at the fiscal court meeting and that the conference call, and who was on the conference call. He challenged me, I was not allowed to speak, when this call took place and who was on the call. And he spoke nothing to it. Marvin was not on the call, and I sent that email stating that to the judge, to redact that. It's official statement from the state. Cora, you can pull my email. My take on that, I think it's ultimately the judge's own responsibility to speak for himself. And he did so through written request, and the cabinet redacted the statement, which included his name on the conference call. I don't think it is Marvin's responsibility to do that when he was not onto the conference call. Okay? And that in the letter was simply an introductory statement opening to the letter to request a meeting. It had no bearing on the intent of the letter, and any focus on that insignificant detail makes the whole importance of this process bogged up. So again, the second part when he says a letter dated June 22nd, which is what I pointed out, he did not stand up to the judge's defense. Again, the judge has the ability to stand up for himself, and he did, and the state redacted it. So I feel like that issue was taken care of. Not only did we say we're not going to acknowledge any committee that was not set, but that was corrected in our record. So I don't feel that Marvin needed to stand up at that time on something that was already solved with the state and officially handled. I think the judge took care of that himself. He wasn't, yes, Marvin was included in all the correspondence. But again, this was between the judge and the state. It wasn't between Marvin and the state. I needed to redact what I had said to the judge. Marvin had no part in this. This was between the judge and the state, and the judge handled it. So therefore, Marvin really had no part. So that's to address that part of the letter. Now, the fiscal court meeting on June 26th, we attended, and at that point, we had brought the information that I have for you today about local determination and about what the county has to do in order to complete statutory and regulatory requirements to get the expansion completed, okay? And we wanted to speak on that, and however, the judge would not allow us due to time and agenda. So in response to that, he said he would like to have a meeting and discuss these ideas with us, which of course we were welcome to that. July 3rd was decided into the court, and the judge was not able to make that meeting at that time. So the letter was to state that we will work with you and set another meeting, which we did on July 20th, which he did attend. So he was able to get the packet of information and ask questions at that point. I may say on July 3rd, Marvin not only listened to what local determination was and how to do the steps, but he took the notes and asked the questions that he needed to start the process. The first part of local determination, it's a multidimensional process, okay? And it's contingent upon renewing contracts, negotiating fees, establishing terms for host agreements, meeting local ordinance requirements, responding to public comment, adopting formal resolutions, and certifying documentation to be submitted to the division for final approval. All these things have to be included for local determination to be done correctly. It's not an easy process. It's not something you can do in a short period of time. Invested parties should plan for at least 6 months to work through local determination. Okay? The steps that we explained, and if you want to hand out the folders for me, the steps that we explained to the fiscal court that were in attendance, to the 109 board, to the public, whoever wanted to attend this, are shown on this document right here. Okay? The preliminary actions is first to receive a notice of intent from the landfill. The state has that happening on August 9th, 2018. The NOI got to Marvin. Okay? He reviewed the notice of intent and reviewed the plan and facility status, which he and I discussed at length. There are points in the plan that specifically ask, are there expansions planned in your area this planning cycle? Your plan says non-applicable, okay? The reason why we have that there is because solid waste, local planning, we have to work with you on getting that done. There are several other points in the plan that speak to the same. Basically, it's a black and white moment when it comes to inconsistency with your particular plan, okay? Marvin and I discussed that. He verified planning and zoning requirements. There was an issue with some planning and zoning. Marvin took the time to do that. Verify siting ordinance procedures. He and I talked about ordinances and how you may want to shore up some of your ordinances as time comes on. The next step is negotiate a host agreement and host fees. Now, we advise counties to do this because it protects you, it protects the residents, it protects the environment. There's more than just fees in a host agreement. This is where you can Ask for benefits for your community. You can get educational material for your citizens and for your schools. This is where you can get PR, you can get websites, you can get this information out. You can teach your residents to recycle, reuse, and repurpose and have that landfill help you with it. You can make sure that if something happens, a tornado comes through and it tears up that landfill and throws debris all in the neighborhood, that you as a county are not responsible for cleaning that up. They fit the bill and help you, okay? If there's compliance issues with the landfill, this is where you look at compliance issues and see if they're polluting the environment. Are you drinking dirty water? Do you know? You don't until you start looking at that. Are they a good provider of services? Collection fees. Do they provide collection for your residents? Do you check the Facebook page? Do you check the Better Business Bureau and see that your residents are truly happy with the service that they're receiving from this landfill? These are the things to consider in a host agreement because you can put terms in there. Enforcements, you can charge fines if they do not do what they're supposed to do. That not only can help your budget, but also make a better neighbor for you. This is an opportunity to do this and is much more than just fees. In return, the landfill, true, can ask things of the county. They can ask for help with PR, can ask for help with educational material. There's a give and take in this. So this is something that can enrich both. So the county, it's to benefit the county when we do this. But again, we don't interfere in those local decisions. What we do is make sure that you follow statutes and regulations to do this correctly. Up to this point, Marvin has done just that. August 9th, 2018, the NOI went to the 109. 8/28, he put a public notice in for consistency. This was after long conversations with him about how to do this and what it means for the county. 9/14, while doing all this, a host agreement had been drafted and given to the landfill. 9/28, at that point, he could have stopped. If you look at the review, preliminary actions, he could have stopped right there. Marvin didn't. 9/28, he went ahead and had the hearing, and he went ahead and passed the resolution and considered it inconsistent. He went above and beyond his steps where he needed to go. What takes 6 months, Marvin got mostly done in 2. So from the process from 8/9 to 18 to 10/9/18, Marvin did all he could do to accomplish the local determination process. We are at plan amendment stage right now. You can't turn in your plan amendment until you decide on either a host agreement or what contracts you would like to have in place. He cannot move any forward from that. He has accomplished in 2 months what other counties take 3.5 months to do. So he did not hold up the process at all. Matter of fact, while things were being decided, he called me and asked me what steps he could take to expedite the process, to which I helped him do. Now, as it stands right now, I think there's a bid in and there's a host agreement. That part we have no take in. The state will not interfere in any host agreement. We do not discuss terms of host agreements except in the beginning we give suggestions. And as far as bidding out, we don't deal with that at all. That is a local issue. 2 opportunities. I came to Scott County, or it's not Scott, excuse me, Marshall County, to teach the steps in this, what local determination is. First one, we had to determine authority in the county. There was confusion on whether the fiscal court was in charge of solid waste management or the 109 board. Clearly, the statute says the 109 board. Your ordinance clearly states the 109 board. There was an argument on who would sign the host agreement. The state at that point recommended that the fiscal court and the 109 board work together to do this process. The fiscal court delegates solid waste management and all authority to a 109 board, and that benefits the county in many ways, okay? That frees up the 109, it frees up the fiscal court, okay, to be able to do other things. It helps specialize a 109 board to handle just solid waste. So you have people like Marvin who take the time to learn the process, learn what waste is, your waste streams, your waste flow, capacity. These are things that are very important to your county. Now, these words may not mean anything to you, but let me put it to you in this term. I don't know if you all know Big Run Landfill. Do you remember the New Jersey and New York waste that was coming in and the stink that the people had? That's a waste flow issue, okay? They didn't have a host agreement strong enough to stop that. Now they've got an agreed order, but it costs the county some money because no pre-planning was done. Marvin understood that, took the initiative to learn what those things are to help with the county and help with the landfill, to better manage that landfill. So he has taken the time to educate himself on these words that may be unfamiliar to the rest of you, but I deal with every day. I see counties that don't have things planned correctly and what results from that. And Marvin has gone above and beyond to not only learn, but to try to communicate and explain it. Any conflict I have seen with Marvin, I know you had asked that, I think should be clarified that it's more a professional debate. I think when Marvin was speaking to the fact that there were conflicts on agreements, I don't think that's a personal conflict. I think what he's saying is that's a professional debate on what's right for Marshall County. So I don't think there's a lot of personal conflict that I, as a state member, would see. In dealing with Marvin and what he's dealt with, he's always been professional. But he will speak his mind because he represents Marshall County residents and what's best for them. And I don't think that's personal, and I think that's a professional thing to do. He speaks up for his right, and I think you people should not take things like that personal in a professional situation because that shows insecurity. Professional speaking, we all need to have a voice to make sure that things get done correctly in Marshall County. Now, Judge, you had spoke to the franchise agreement and the 20 years, and I think that's good because that plays into this capacity number I'm talking about that you may not understand or be aware of. Of course, I supplied the information to you twice, so you should know it. It will be part of your planning and part of your solid waste management plan. That plays in with that host agreement. So that's how the host agreement plays in with local determination and why that's important to the state. Now, the plan amendment, we're on section 3 with that. And he has requested a plan amendment, but we are waiting on that host agreement because he can't. So he's waiting. The meetings we had on the 20th and the 3rd were open forum for anyone to attend. Fiscal court, 109 board, residents, anyone could attend for the information. The information we provided is the procedure for local determination, capacity, waste flow, what the county could benefit from not only a host agreement, but shoring up ordinances. We discussed who has authority in the county. We discussed who has authority in the state. And we discussed how the federal, state, and local laws work together. That was the meetings that we had. Judge attended the second one and got the same information. So as far as the letter goes, I think I have addressed the state's policy and what we deem in this letter. If this is the reason that he did not speak up for the judge in the letter to the state, that was an introductory paragraph to an invitation to a meeting, the state says that's an invalid reason to dismiss Marvin. He has kept this county in compliance. He has met all regulatory and statutory goals to decrease waste. He has oversight over the dump grants. And he has kept you from losing, if you're in non-compliant, he has kept you from losing your grant money, the state stepping in and taking over, and stopping all processes that makes waste in the county. Those are the things that happen when you're in non-compliance. Marvin has been very attentive to keep that from happening by doing what he's supposed to do this whole time. He turns in reports on time. He turns them in completely. This is an arduous process, gentlemen and ladies. This takes months. This is a multi-stepped process. At any point in time, Marvin has always asked me with each step if he's doing it correctly. At no time has the judge called and asked me a question dealing with this process. At no time does he know the multi-steps that go along with the process as described. I don't feel that he is educated in this particular process enough to make the call whether Marvin has done his job or not. I, however, am. I'm the compliance. I'm the one who says Marvin's doing it right or not. And he is. He is a month ahead of schedule on this. The host agreement is not part of the local determination process. That's local, and you all have to work that out. But Marvin has done his job to the letter from the beginning since the plan in place this time and last time. Questions?
Yes, I want to clarify some things. First,
Sure.
you stated that you were denied to speak. This is the official minutes for June 19th, 2018 meeting. A motion was made by Commissioner Koch to dispense of the agenda for Ms. True and Ms. DeLong to address the court for 20 minutes. Motion died to a lack of a second. So your implication that I denied you or both of you to speak?
I asked, hold on just a minute, Judge. Minutes are summaries. If you want to watch the video, you can say, if I can have 1 second, I would have told you this, but you said no. So for me, that is a denial unless you want to interpret that another way. Again, minutes are summary. The video will have the details.
The minutes are the official record, and I think that...
Of a summary, that's correct.
Hang on. The minutes are the official record, which I preside over the fiscal court.
Right. Do you have a transcript?
It's right here. Here's the official minutes.
Minutes are not a transcript.
I'm trying to read the official
Well,
minutes.
I'm trying to be pertinent to what we're...
Just let me finish reading this, then we'll move forward. A motion was made by Commissioner Koch to dispense of the agenda for Ms. True, Ms. DeLong to address the court for 20 minutes. Motion died due to lack of a second. That means that 3 other members of the fiscal court did not make a second motion to hear both of you speak. If in that summary of conversation, I state that whatever it is I stated, the fiscal court did not make a second for you two to speak. So I just want to make that clear on the record, the June 19, 28th minutes.
That's fine.
So go ahead.
Right, and at that point, we said we could come back and educate, to which you were unable to attend the first meeting. The letter was sent, we called, and got you a date for the second meeting. Correct.
Okay. Also, another thing I want to clarify.
But, hold on, the point is not that I was denied to speak. The point is the letter to Marvin is wrong. That wasn't me. So, you know, we were talking about redacting on my letter. There are things in Marvin's letter that's incorrect as well. So, again, you know, if we're talking about public record and that being important to you, I think that that needs to be corrected, that it was not me.
Okay. And
That's the
rightfully
point I'm
so,
making.
I can do that. I will
Yes.
make sure that we get that on official record
Thank you.
that it wasn't you. But you also said I never called. June 25th, I did call.
I don't think I said you never called. You didn't call to ask me questions based upon this process. Not that you never called. You never asked me questions on this process.
That's why I'm clarifying, because you said I never called. So June 25th,
well,
I
that's not the
called.
point. The point is you never asked me anything about this
Okay.
process, so that if you're making an assumption without the information.
No, I just want to make sure that I'm clear as far as what
Right.
actually took place. So
The-
on
the
June
point
25th.
is, you never called for information based on this, which is what exactly I said.
Okay. On Monday, June 25th, at 5:06, I believe we ended our phone call. I was speaking with both of you, I believe. And I'm going to read the email that followed. Dear Judge Neal, thank you for returning our call this afternoon to reiterate what was discussed. A meeting with Marvin Stokes, Jeremy Parent, Tim Childs, Jeff Edwards, Judge Neal, Lynn True, and Deborah DeLong was scheduled for July 20th, 2018 at 8 a.m. in the judge's office. Although all persons listed will be invited, none of them are required to attend other than Deborah DeLong and Judge Neal. Other invested parties are permitted to attend from Marshall County as long as it does not constitute a quorum. And these are just notes that we discussed. The county attorney, Jeff Edwards, will send Deborah DeLong a letter requesting clarification on, 1, attendance of the conference call held on February 27, 2018, and 2, the date of the fiscal court meeting attended by Deborah DeLong and Lynn True, the reference of deciding group of committee. Once this letter is received, I will respond accordingly to administrative records in Marshall County.
Right.
And the whole contents of that conversation was to just get our documents correct.
Correct, and which we did.
So I just want
The
to make
cabinet
sure
did.
that, that is stated on the record.
Right, yes. The email that you sent was to correct the things that we did redact. Again, it was not to ask questions about the procedure, nor was it to ask the steps involved. It was to redact the points in the letter. You're right.
So, question?
I've got a question.
Yes, sir.
Are you the one that initiated the conference call that you were referring to?
Yes.
Okay. Is there a reason Mr. Stokes wasn't a part of that?
The conference call, we work with the 109 chairman, and that was an impulse call to Jeremy because the letter came into our cabinet. And so I called Jeremy to see if we could set up a meeting. So the whole point of that call was not to discuss action, was not to discuss any more than, hey, this is a lengthy process, it's hairy. So you've got maybe a host agreement that's expired, we need to get together and do this. The voices on the other end were like, yeah, this is important, we need to do this. That was the extent of the conference call. So it was not to discuss any action, it was not to discuss anything concerning local determination, other than there are steps involved and everybody needs to be aware and be educated before we start this process. Or you're not going to follow statutes, regulations, you'll be out of compliance, and you could lose your grant funding. So that was the whole point of the phone call. It literally lasted 5 minutes.
I did have one question. I don't know if you guys can answer it, but is it common that the state would give grants to counties that do not have a host agreement in place?
You're misunderstanding me.
I'm just asking, is it uncommon?
Well, grant funding is not tied to host agreements. It's tied to plans and planned amendments. Host agreements are loosely tied to that. If you decide that you want a host agreement, and that is your choice, whether you want one or not, okay? The state has no input on that. We advise it's a good idea because you're missing out protecting your residents, protecting the environment, and also enriching the landfill and businesses in your county.
Now,
Okay.
let me
Hold
make...
on just a minute. I'm not done, Judge. So we say with that, we advise that, okay? If you decide to do that, that then becomes part of your plan. If you're out of compliance with your plan, that is when your funding and things can be taken. It's up to you to decide if you want that or not, but once you decide yes, and with all things saying in Marshall County, with you drafting a host agreement, of course the state's going to say, yes, you apparently do want one. That becomes part of your plan. So indirectly, yes. If you decided against it all of a sudden, then that's fine too. It won't be counted as part of your plan, okay? But in no way and shape is grants specifically tied to host agreements, nor does the state have any input on local agreements and what you decide to do. What we do is make sure that your plan is in place so that you know what to do with your waste, because by statute, you have to take care of your waste in your county. We don't want you to pollute yourself or your neighbors. So we make sure that whatever you decide to do is within reason. But the decisions are yours.
Who writes the grants? Who applies for the grants?
Well, it depends upon the grant. So give me a specific.
Well, when you say yours, is it both the fiscal court and the 109? Let me just jump to the chase. The past 3.5 years, it's normally been the 109 district that would seek those grants. It wouldn't be
That's
the
right. They're
fiscal
the ones that seek them.
So when you're saying yours and theirs, I just want to make sure, is it?
Well, I don't think
Speaking
that
about
the
the fiscal
109
court or the
board is
109?
there. See, this is the disconnect what we're speaking of. There is no mine and yours. This is Marshall County, and the county fiscal court and the 109 board need to work together. So when I say yours, it is yours. This money is yours to help your county. The 109 may apply for them, but they do that as a representation of you. So there is no mine or yours. This is a concerted effort by local officials to get this done. Just the task of applying is done through the 109 because they have the authority to do so. Do you have anything to add?
Deborah, you made a comment to me earlier, and I just want you to clarify or restate that for the board. How would you say Marvin compares to other board chairmen that you've dealt with in the past?
Marvin is one of my 109 board members that actually ask the questions. Through this local determination process that takes time to understand, he has reached out to me consistently. He has followed and is in compliance. He has maintained professionalism with dealing with the state and making sure all requirements have been met on time. Marvin asks the important questions. He's not afraid to speak up. He's not afraid to give me the what-ifs so that I can help him understand this very complicated process. He has invested time beyond his workday to contact me at hours when he's had questions. He takes his job extremely seriously. And at the state, because he's kept Marshall County in compliance, we think he's one of the better 109 people. He has taken charge on this. Now, you asked me, what?
You answered.
Did I answer it? Okay.
Any other questions?
No.
Anything you want to add? Thank you.
I will just add, and to support everything that Deborah just said, I reiterate everything that she said.
Will you explain your relationship to her?
I'm Deborah's supervisor. Our section specializes in providing guidance to local officials. With the case of Marshall County, we've all established the governing body for solid waste here in your county is the 109 board, the chairman being Marvin Stokes. So I'm Deborah's supervisor. We are a staff of 4, and we specialize in helping the local government work through a local approval process for siting and constructing facilities. There is nothing more difficult in all of solid waste management. There is no other activity that is more difficult than siting or expanding a facility. And it's because of exactly what it is. It's the nature of it. People do not want a landfill in their backyard. You do. You have one in your backyard. Make the most of it. Get an agreement, get a contract that's meaningful and worthy. Exercise your right to control the flow of waste in and out of this county. I promise you, you will not regret it. Plan properly. We'll help you do it. We want fiscal court and the 109 board to cooperate on this. We want you on the same page. But at the end of the day, the 109 board makes all the decisions regarding this process and signing off on any contracts. It's highly advisable you put a contract in place. And not just for the interim, not just for 20 years. 20 years, according to a franchise, according to our Kentucky Constitution, it cannot exceed 20 years. However, that plays into capacity for the landfill. If you authorize that landfill, which is kind of where you're headed, if you authorize that landfill an overinflated amount of capacity, you'll be married to this landfill for the next 100 years. So we're just trying to educate you as to how to properly make decisions regarding this. This is our job.
Right, and we want to make sure that the landfill has enough capacity to handle your waste first. And you do that through that capacity number in your plan and through host agreements. Because there's an in area and there's an out of area. And that capacity number, they have to make sure that they take your waste, but we want to make sure that they can for the next 10 years. So that's why this is important and why that you need educated on this. None of the states, counties, have been educated up to this point on this. Host agreements have been lacking. Sometimes they ask just for money. Sometimes they talk about just disasters occurring. There's so much that can be nailed down in Kentucky. We are 20 years behind in planning with other states. It is a shame that these other states are so far advanced than Kentucky. So by starting to educate yourselves with the planning and how to do things, we can maybe shore up some things that you may not want in your county that may end up in your neighborhoods through working with the 109 board and Marvin. Marvin took the time to learn that and learn about capacity and how that plays into it.
Our initial interactions with the 109 board, Tim, Jeremy, Marvin, I can't tell you how delighted Deborah and I both were to finally see some local officials take this seriously,
Yes.
want to learn the process and want to do it the right way. It's complicated, it's lengthy. All these minutia details that may or may not have been included on a phone call, that's irrelevant and not significant to any of this. What's meaningful to this is you've got some local officials here that want to do the right thing for your county, and we want to help them continue to do it. We hope that we got our point across with that. That's really all I have to say.
Our main goal is to protect human health and the environment, and that's been Marvin's main goal as well through this process.
Deborah, can I ask you a question?
Yes, sir.
In your correspondence with the 109 board, and I echo everything you said about Marvin Stokes. I've known him for 50 years, and I find it very, I certainly appreciate you and Brian and Lynn being here, but my question is, there are 4 members on that board. Some of these
Yes,
are
sir.
listed in the reasons for termination, that letter. Do you know, or has any of those other 3 members of that board contacted you one time to ask you any information about anything?
No, sir, I've not gotten any contact other from Jeremy, Tim, and Marvin Stokes about this process. I have not contacted or heard from any other board members personally on any topic at all.
So my whole point is, when Brian Miles was here and got you ladies involved, and we're very appreciative of your.
It's statutory that we're involved. We're here because no matter if we got invited, we were here.
When we contacted you and asked for help down here, because on the March 23rd meeting of 2018, the members of the physical court and the superintendent of the refuse and the waste management coordinator and the chairman, Marvin Stokes, were there with the county attorney and the refuse attorney, and we all admitted, nothing to be shameful of, the 2 attorneys knew nothing about waste management, nothing about the laws that pertain to it, and we're best served by bringing people in that do know. And you all have been nothing but helpful. Gary Logston, you're all's head honcho. I've met with him several times and different functions and so forth, and expressed our thanks as at Marshall County. But your mission is our mission. You're here because that's
Right.
your job, to protect the citizens.
It is, environment and human, but we also are statutorily required to educate you, whether you want it or not.
In that March 23rd meeting, and I understand that. In that
Yes.
March 23rd meeting, we had, our biggest concern wasn't finance or the monies coming in here. As Brian was here, and he asked me before we got that meeting, and then he asked his entire body on March 23rd, what do you want to see out of this host agreement? And it was unanimous, and commissioners that not involved, you can get that audio. It's a 2-hour and 3-minute audio on March 23rd meeting. Now, Denise wasn't here, but you can hear it in length, and it would be very beneficial for you to listen to that. But our consensus when we left there was, number one, we want Waste Path to stay there. We don't want to cripple Waste Path with any regulations. We want those jobs to stay there here in Marshall County.
Right.
Because they serve a purpose. They get rid of our waste, our household waste from our green boxes. They serve the Calvert City Industrial Complex.
Right.
And certainly a mile down the road in a safe and effective way. But we want not only financially to be this beneficial, but because if those people leave, the garbage stays. It's here for the rest, from
That's
this
right.
point on.
The decisions you make
Sure.
today with
But
this host
we weren't
agreement,
worried
your
about, as a
grandchildren will live
consensus
with.
that day, we weren't worried about on March 23rd,
That's right.
just strictly the finance. We were worried about the health, safety, and environment, and where this garbage was coming from, and control, and to make sure that Waste Path is in compliance.
Correct.
And I challenge the commissioners to contact these ladies and find out the answer to those questions, because it's eye-opening. And contact this gentleman. They're here to help us. They don't, politics is not involved in this. They're here their job is to protect the environment of the Commonwealth of Kentucky.
Let me say this. We have provided educational material for those that are involved. New ones will be glad to come down and educate. I've left a folder with you currently. However, we're at a compliance moment, ladies and gentlemen. We have educated the county on what needs to be done. It is up to you now to make decisions based on it. It's a matter of getting the forms and things done. Now, if you want to reach out and have us educate you, if you're new to this process, we will be glad to do that. Those involved, Marvin has done a good job up to this point to lead the game. He has the information, and he can share with you as your 109 chairperson. If you decide to remove Marvin, and that's, again, nothing to us as far as state goes. We have no investment on who your 109 chairperson is. You'll need to do a plan amendment. The 109 chair has authority over your plan. So the next step that I want to leave with you on that is any decision you decide to take today, please consider that a plan amendment is going to have to be done if you decide to move forward with any decision, according to Marvin, if it involves changing your 109, which adds a public notice, a public hearing, and a little extra time to get that done. So that's going to add 2 more months to the process before you can begin again. That's statute and that's regulation. I can't do anything about that. I'm simply telling you the impact of what will happen with the state as far as the paperwork you'll need to process. If you do not have a 109 chair, then when you do elect one, then that's what they'll have to do. So please contact me, and I can get the process started if that's what you decide to do, okay? Because if you don't, then you're going to be in noncompliance. I don't want Marshall County to be in noncompliance, okay? So make sure whatever is decided that you please let me know so that I can help you adjust what you need to do.
And that's how it ties into grant funding. When you're out of
And that's how it ties
compliance,
into
you
grant
don't
funding.
receive grant funding.
Right.
The county does not receive
Yeah.
grant funding.
So that's what I want to leave you with is whatever your decision is, please make sure to communicate that so you don't go out of compliance. And Marvin has the knowledge to continue this, so I guess you'll have to start the process of learning this all over again. So if you need us to come down and start this process all over again with education, I'll be happy to do that as well. So please make sure you let me know so that I can put things in place to keep you in compliance and keep you educated so the ball doesn't get dropped. Because I know Waste Path wants their expansion, okay? The county wants the expansion. That's not the argument here. It's a matter of following procedure to get to that point, and that has to be done because it's state law. So make sure you contact me so we don't lose any more time getting this done than we need to.
I'm curious, one last question on the training that we got on the, I believe it was the 20th.
Judge.
Did y'all have a sign-in sheet of who all
Did not.
participated? Okay.
Did not, because it was open forum, anyone could attend.
Okay.
So we didn't take record for that on the 20th, but you were in attendance.
Yes, I was there. I'm just
Yeah.
inquiring if, I didn't really see anything in the minutes for the 109 board, for the board members to show up. There may have been discussion, I don't know, but I don't think I know Denny was there, I believe, but I don't know if some of the other board members were there.
Yeah, it was at the library. Yeah,
It's information, it was an informational meeting.
Correct.
So therefore, a quorum wouldn't be consisted.
Yeah, right. It was open forum, so we didn't,
Yes.
because this is something that we provide for anyone in the county.
Correct.
And it's not a requirement, so there's no need to have a sign-in sheet for
Correct.
that, because it's not something we're going to track.
In my opinion, it would probably be something the 109 board would want to have
Correct.
for all their board members.
Right.
Because I noticed that there were some that didn't show up. Now, I don't know if they knew about it, I don't know.
Yeah, I
But-
don't, I know that it was communicated to everyone. I know Marvin and Jeremy did a good job about spreading the word. I have no email to that, so I just know that I had asked Marvin and some had other things that they needed to do. I do know that. That was a side conversation before I started it, was Marvin, is anyone else coming?
Right.
Yeah, they were all invited and urged, so before I started, I asked, and
And I just bring that up because the last correspondence I had of it was after our phone call, as I read earlier, that we would be meeting on July 20th.
correct.
And then that changed.
No, we met on July 20th.
No, I mean, we were meeting, Deborah and I were meeting in my office.
Right, and
on July,
because it's
but
an
somehow
open
that
meeting.
changed.
Right, it was an open meeting. You and I communicated that more people were to attend, and your office was too small for that. So we moved it to a bigger arena for that. That was something that was communicated. That's how come you know to show up.
Okay.
You knew it.
I just want to make sure. I called you, and then your email preceded my phone call. I'm citing your email.
Okay,
I don't have any other correspondence that it was going to be other than, I believe, a day before, county attorney said there was a meeting. That's what I'm saying.
we decided on the phone call. I've got a witness that says we decided on the phone call.
Here's your email that preceded right after the phone call.
Okay,
It was that, your scheduling date was for me and Deborah to meet. We were going to meet in my office, but apparently it changed to the library.
because it's an open forum meeting. You and I said that on the phone. More people wanted to attend, so we decided to have it in the library, which apparently you knew because you showed up. So at some point, we talked
Okay.
about that.
Maybe, I'm just going to put,
I'm
again,
confused
this on
about
this
what
on the
should-
record. The phone call, the phone call took place at 5:06 PM on Monday, June 25th.
I'm confused why this has to do with Marvin and what we're here for.
It's
I'm-
it's
you know,
clarifying
I-
some
I
of your
don't know.
comments.
I don't know.
Everybody behind me is confused as well.
Hang on. We had a phone call.
We did,
Your email immediately preceded the phone call.
probably.
It did. I've got it right here.
Okay.
In the contents of this email, there is no public meeting at the library on the July 20th. It is the meeting in my office. What I'm simply saying
And then,
is that changed.
yes, it did,
Okay,
which we communicated because you showed up, so you knew.
but who did you communicate that with?
Apparently you, because you knew and you showed up.
No, you didn't.
Oh, well, somebody told you. You
If
showed up.
okay.
And
If
again,
you
what's
can-
this got to do with Marvin? You showed up at the meeting,
I'm-
so we've established that.
Ma'am, I'm clarifying your comments. You're
Okay.
saying that you notified me. I've got
Okay,
an
you have an
email
email.
right here.
That we have a
We
meeting
were-
on the 20th.
The original meeting that was scheduled was changed.
Judge, I really, I don't know if you've heard the word bird walking, but I really feel like this is what this is. The main point of the
Oh, yeah.
meeting today is to determine if Marvin has done his job or not.
Yeah.
And all of these points are really not important, and I've spoke to that. So if you have a specific question dealing with Marvin's ability to do his job with the state, I'll entertain it. Anything else, I think, is kind of bird walking.
I would like you to send me your communications of the change. That's a simple request.
You can request that through Cora, through the open records request. I can't send anything without that, and I'll be glad to leave you that information. Which has already been pulled, by the way, I think by the county, so I think you guys have it already, I'm not sure. But all communications have been communicated. But if not, please feel free to contact Cora and get anything you need.
Procedural guy. We'll fill out the open record.
Yeah, you have to. That's policy. That's not,
I understand.
yes, that's policy. It has to be followed.
Not a problem. Thank you.
Thank you.
Anybody have any relevant questions about Marvin Stokes? Oh, we're getting late.
Or about the process. I'm willing to talk about the process and what Marshall County needs to do next as far as local determination and the requirements that the state needs. If not, please feel free to contact me. I'll leave my contact information. I think it's in the packet, and I'll be happy to educate, explain the steps, help you get there.
Thank you.
Thank you, Judge. Thank you, Court, for your time.
Thank you.
Oh, sorry. Thank you.
Yeah, but one final comment he wanted to make before we finish.
Fiscal court, you all have heard a lot of information today. There's one thing I want to make sure that you have clear in your head. Currently, under the proposals that have been discussed, talked about, and sent back and forth, WastePath is asking for approximately 80 to 100 years worth of disposal. We're talking about a 20-year contract. At the end of that 20 years, they could sit back and say, we don't need anything, we don't want anything from you, so therefore we don't need a host agreement, and everything can go away. There's a process that's being followed, and I just want to make sure that you all are very well aware of the impact of the decisions that you're going to make. This isn't a 5-year, 10-year, this isn't a tomorrow decision. This is something that will affect the residents of this county for the next 80 to 100 years. Thank you.
I'm just going to state the public notice that the 109 board put out. This is the actual bid. We'll put that on the record so it states the terms laid out that they put out. One other thing, I'm going to read the official minutes, clarify what was spoken about earlier. January 5th of 2017, stated that we had a 2-hour conversation. And in that conversation, we discussed call-out or policies and increasing, and I called you back that day, correct? Correct. I want to read the official minutes. Well, give me a second. January 5th of 17 is the date that is on my calendar that you and Rick came to my office. Say in that meeting, we discussed call-out policies. This is the official minutes of the fiscal court dated November 1st of 2016. This is section D of the official minutes. The road department call-out policy was discussed. Assistant County Attorney read the new call-out policy. A motion was made by Commissioner Cock and second by Commissioner Boland to amend the road department call-out policy as stated. All voted aye. Motion carried. And as I stated earlier, I believe you're getting your meetings mixed up because on January 5th, 17, it clearly states that there was action in court prior to January 5th of 17 about the call-out policy, because I do remember speaking to you about that, but it wasn't on January 5th, 17th, so I just put that on the record.
You are wrong there. I was at the meeting.
But it wasn't on just the call-out policy,
I-
it was about days, vacation, holidays, and all that in your overtime policy. It was in that meeting, Judge.
Go ahead, Mr. Hendricks.
I just want to make one final comment. Unless anybody has any other proof or questions, or.
I'll finish up with my,
I've
go
got
ahead.
one final question for Mr. Stokes. The 109 board has an attorney that represents you, correct?
Correct.
Did I understand it right?
Danny Danny knows. I know.
Okay. For a couple hours, all I heard mention of was our previous county attorney, Jeff Edwards' involvement in this. Since the 109 board has complete authority on this issue, is Mr. Knoll involved in this at any point in time through here, consulting or any kind of involvement?
Still is, as far as I'm sure. Jason Darnold can ask that very easy. Him and Denny are good friends, and I'm sure they're still corresponding over the host agreement.
Yeah, he had, Denny had sent the bid, what went in the newspaper, the bid to me, and I looked over it, and he and I had some discussions about it, and, you know, we both thought it was a good-looking bid and sent it out. So, yeah, I mean, we stay in contact.
Thank you.
Denny could not be at the last meeting. I opened the bid because I had a council there. We just tabled the bid, and then Denny will come in and pick up from there. Yes, he's.
I just didn't hear any mention of him when
Oh, so you already have
Edwards.
something back? Is that what you said?
Already has a
You already
bid.
have, you already have a
I
bid?
opened the bid the last meeting.
Oh, okay.
then we
Yes,
tabled
there's,
because we had no
Waste
counsel
Path
there.
submitted a bid.
Oh, okay, that's what I meant, yeah.
Yes.
So
Yeah.
that-
Yeah, it's
you got
tabled.
something back.
Kevin, for the dates in here
But you
that I
can't
outlined in my letter,
Receive
Denny
anymore,
was not present.
right? We're past
No,
that date.
correct.
so
It's
just
time's
you-
expired.
You just have to move, or,
Yeah.
meet again to be able to open it.
Until well, it's open, and it's tabled, and it's ready for discussion, and
I got you.
go from there.
Gotcha.
On Denny's advice, not mine, on Denny's.
I appreciate it. I just didn't know if there's a reason he wasn't involved or
No,
what. Okay.
All I want to say in conclusion, as his attorney, is that I could stand up here and regurgitate all the information that you heard today, but we've already had 3.5 hours of that, and I'm not going to do that. Gentlemen, you've heard the statements by all the witnesses, and the people who know what they're talking about have stood up here and looked you in the eye and told you that Marvin Stokes has done exactly everything that he's supposed to do. So, your duty is to protect and serve the people of Marshall County. And I think that keeping Marvin on this board is doing exactly that. I think that's the only choice you have today based on what you've heard. Two ladies came from, did you come from Frankfort? Two ladies came from Frankfort to tell you that, and another gentleman came from Grant County. If you don't know where that is, it's about 30 minutes south of Cincinnati. With no obligation to do so, to tell you those things. So, this is about substance and not politics. This is about people of Marshall County, and that's what you're here to do. So, removing Marvin from this board would be a horrible choice, and I think that's been laid out to you very clearly by the people who have spoken to you. Thank you.
For the record, I'm going to submit my letter that was sent out dated January 22nd, 2019. And there's no surprise, I mean, it's even been stated, that Marvin and Rick have been friends for 50 years. And I think that, unfortunately, to some degree, had clouded the activities that should have been taking place. But, I presented this. And I stand firm behind it. And Marvin, I know we have family that go back, but what I've observed since then, over the past couple of years, that's why we're here. Without any other questions that y'all may have.
How will this process continue from here? You're procedure's important, so I want to get it down. When will a vote occur? When will notice occur as to the decision?
I'm going to say on our behalf, I mean, individually, this is a lot
Yeah, I
to
understand
take
that.
in.
I expected you'd want to reconvene, maybe your next meeting or even after that. But
Yeah, I don't know, officially, obviously, we can't discuss it amongst each other without there being a quorum, so I assume we'll all make a individual decision and vote on it at the next.
Well, I just want to read this. This is an OAG opinion. I'll give you a copy of it
Okay.
if you want it. OAG 05-OMD-86. And this is talking about the removal of a student government association member. I think it had to do with University of Kentucky, but I'm not positive on that, but I'll give it to you. It just basically says that, of course, we had the public hearing, but it says that removal of a member of the SGA, the body could go into executive session to discuss it before coming back out and voting on it.
And Jason, I'm not attacking you in any way, but is that the closest you could come up with as far as how to proceed? I mean, we're talking about a student government, not an appointed member of the county.
Well,
Again, I'm just asking for.
is there something about that that was funny? Okay, well, I'm just asking because this is interpreting state law. It's an attorney general's opinion.
Okay.
And it says that they can go into executive session to discuss before coming out to vote. So
Okay.
that's the closest thing that I
I'll
could
just
find.
look at it. Okay, that's what I was asking. If you had, thank you, I appreciate it.
I couldn't find any decisions interpreting 65-007 at all.
And by executive session, within this, because, am I right, are we the only 3 votes?
No, you got 4 votes.
You got 4 votes, so you're saying that if we went into executive session, it would be all 4 of us?
Yeah, the statute says appointing authority,
Okay.
so it's all 4 of us.
And you don't have to. I mean, if you don't want to go into executive session to discuss it, you don't have to. But that's an option you have.
But that has to happen through a regular session.
Correct.
Okay.
We're going to close the hearing.
Okay,
We're going to finish our regular meeting that we had this morning. And then on March the 5th.
March 5th, okay. At
9:30.
9:30, thank you, I appreciate it.
Okay.
Thank you for
Would
that
need,
information.
we would need a motion to adjourn from the public hearing.
So moved.
All those in favor say aye. Any opposed? Motion carries. We need to come out of recess to go back into regular session to finish county business.
So moved.
Second. All those in favor say aye.
Aye.
Any opposed? Motion carries.